Good afternoon. Welcome to the Appellate Division First Department. Oral arguments for today, February 18, 2021. I will now call the calendar. People versus Raphael Jackson.
Good afternoon. David Bernstein for Appellant Raphael Jackson.
So you have 8 and 2.
Thank you.
Respondent.
Good afternoon, Your Honor. Alice Wiseman for the respondent.
8 minutes. Rosen versus Chronic Bartash, submitted. Hindlin versus Advanced Alternative. Appellant. Hindlin versus Advanced Alternative.
Good afternoon. It's Mark Zauderer for respondent.
Hello, Mrs. Zauder. What happened?
You seeing me, I hope?
Yes. 5 and 3. Respondent.
I'm sorry? For respondent, Mark Zauderer. Yes.
Oh, I'm sorry. Appellant. So, Mrs. Zauder, you have 5. It's 5 and 3 for the appellant.
Right. I'm prepared.
Okay. So do we have the appellant?
I'm not
Okay,
here.
I guess we'll come back. Golden versus Levy.
Peter M. Levine for the appellant.
6 and 2.
Thank you.
Jennifer Cohen-Bigder for the respondent.
6 minutes.
Thank you.
People versus Shakim Iwika, submitted. 2157 ACP versus Famous Industries.
Joseph Altman for the appellant, Famous.
5 minutes. Respondent is submitted. Mota versus Mota, submitted. Fawn 2nd Avenue versus First American Title.
Good afternoon. Jamie Katz-Sussner with Sills Thomas for the appellant.
6 and 2.
Thank you.
Respondent.
Matthew Hurl from Goldberg Weprin.
5 minutes. People versus Tyrell Williams.
Good afternoon. Jan Hoth for appellant Tyrell Williams.
8 and 2.
Cynthia Carlson for the Office of Darcel D. Clark. Good afternoon, Your Honors.
Good afternoon. 7 minutes. Just so you know, this case will be called last. I am recused on this matter. Justice Singh has been vouched in, so it's going to be called at the end of the calendar.
Thank you.
Samos versus New York City Department of Buildings, submitted. Gamez versus Kew Gardens, excuse me.
Glenn Kaminska for Kew Gardens. Your Honor, I have an agreement with Alpine that we will simply submit at this point.
Alpine?
So
no,
the agreement
just the Kew Gardens appeal is going to be submitted.
Yes,
okay.
The agreement was that we would submit the issues with respect between Alpine and Kew Gardens, and that I would argue with respect to my arguments against plaintiff.
So you're going to argue as to
my arguments against plaintiff.
Okay.
I'm David Schwartz. I'm for the plaintiff respondent, Jose Gamez.
Initially, I believe you were given 6 minutes. Is that correct?
That's fine.
Okay. D'Artagnan versus Sprinkler Inc.
Stephen L. Dreyfus for the appellant D'Artagnan, Your Honor.
7 and 2. Sprinkler Inc.
Pardon me, Your Honor. Was that 7 and 2 or 7 and 3? I had been told
7 and 2.
7 and 2. All right.
Sprinkler Inc.
Yes, Gavin J. Rooney for Sprinkler.
7. Solomon versus U.S. Tennis Association.
Brian Isaac for the appellant, Your Honor.
5 and 2, Mr. Isaac.
Thank you, Your Honor.
Good afternoon. Megan Brown for respondent, United States Tennis Association and United States Tennis Association National Tennis Center.
We have 2 other respondents.
Yes, good afternoon. Rob Denny for respondent, Levy Restaurants.
Good afternoon. Lana Ivy for A&A Maintenance.
So 5 minutes for each respondent.
Thank you.
T&M trusteeship versus BDO USA is submitted. Houston Casualty versus Cavan Corp.
Glenn Kaminsky for the appellant.
6 and 2.
Yes, Your
Aiden
Honor.
McCormack for the respondent.
6.
Thank you, Your Honor.
Okay, so again, please, as we're doing this virtually, it's really important that you keep your mics muted unless you are in fact speaking, so we don't get any feedback. Also, please just be reminded, do not speak over the judges. And also keep in mind that we have your briefs, we've read your briefs, so we are familiar with the respective arguments. First case up is People versus Raphael Jackson.
Good afternoon, Your Honors. David Bernstein from the Office of the Appellate Defender on behalf of Raphael Jackson. A basic tenet of criminal procedure is that the jury gets to make findings of fact and evaluate witness credibility, including a defendant's credibility. But the trial judge here prevented the jury from doing that by denying the defense a temporary lawful possession charge. In considering the request, the judge took issue with the fact that Mr. Jackson's testimony had some inconsistencies, complaining that it was all over the map with so many snippets of testimony. How do you make sense of them? I don't know. Of course, he didn't need to know because decades of case law require that a judge give the charge and let the jury sort out those kinds of inconsistencies. Instead, the judge here stepped into the jury's shoes and made the ultimate determination for them, effectively concluding that there was no temporary lawful possession and denying the charge. This was improper, as even the trial prosecutor initially conceded on pages 439 and 444 of the record that, viewed in the light most favorable to the defense, the charge should be given. But the judge eventually talked him out.
Counsel, under what circumstances would have been temporary lawful possession? I thought that the testimony from your client was that the gun had been taken from his girlfriend's deceased boyfriend or husband weeks or months previously. It had been safeguarded in the apartment, and that your client had not made a determination as to when he was going to return the weapon, or even if he was going to actually return the weapon to law enforcement, or whether he was going to dispose of it in some other way.
A few corrections to that, Judge. Again, and I would just point out that in considering whether the defense is entitled to this charge, the evidence has to be viewed in the light most favorable to the defense. First of all, and so looking at Mr. Jackson's testimony, his testimony was that, and it's undisputed that it was Ms. Jones who brought this weapon into the apartment inside this lockbox. She brought it into the apartment. Neither of them knew it was in there. Mr. Jackson's testimony was that upon opening it, she took responsibility for turning it over to a friend of hers, an NYPD employee. She was going to surrender it, and she took sole possession of it. She put it in a closet that contained her clothes, and Mr. Jackson testified that he did not see it after that for several months. So there was a factual question here for the jury to resolve as to whether he still had any kind of responsibility for it being in the apartment still. And so what his testimony was that eventually, the morning of the altercation here, Miss Jones gets upset. She goes and opens the box, and he sees it for the first time in months since they first discovered the gun. And at that point, he grabs it from her to disarm her and leaves the apartment immediately. So the temporary lawful possession would have been from the moment they opened it and Ms. Jones agreed to take responsibility for it and to surrender it to. Yes.
Didn't he actually provide testimony before the grand jury that's contradictory to what you're saying now, that he did actually know before she actually took out the gun to allegedly use it the day of the incident that it was in the apartment?
Well, first of all, what happened in the grand jury is not relevant for the sake of this argument, which is that viewing the evidence in the light most favorable to the defense, he was entitled to the charge. And if you look at there's plenty of Court of Appeals case law that says that a charge like this must be given where there's proof in the record showing a legal excuse for having the weapon. The court has never said, and this court has certainly never said, that proof must be unimpeachable proof. And this makes sense.
Again, I thought that he specifically testified that he and admitted that he told the officer that he was either going to throw it in the that he intended to either take it to the precinct or destroy it by throwing it into the river or in the garbage.
2 points, Judge. First of all, for a disarming temporary lawful defense charge, it doesn't matter what the defendant was intending to do with it after he disarms a wrongful possessor. But more importantly, that was not his testimony at trial. His testimony at trial was that he left the apartment intending to surrender it to the precinct. What you're referring to is actually part of a statement he made before trial in ECAB, I believe, with a prosecutor. So again, and this is, I can't emphasize this enough, because the standard for reviewing whether a defendant is entitled to a charge is liberal for a reason, because it implicates a defendant's right to present a defense. And the Court of Appeals has said that the process of considering a defense charge is incompatible with weighing the evidence to resolve competing inferences.
Counsel, does the fact that the gun was loaded at the time that it was found on your client's person, and the fact that he saw police and he didn't alert them to the fact that, listen, I have this gun that I want to turn in, does that somehow weigh in to the court's decision not to charge a lawful transitory possession?
Well, 2 points. First of all, as a factual matter, the testimony was that essentially within a minute or two, it was a few minutes of when he stepped outside. I mean, he was caught in the courtyard within sight of the exit from the building. So this is not a situation where, and he was, 2 officers approached him immediately, surrounded, and it all happened very quickly. But I think more importantly, again, Mr. Jackson's testimony was that he intended to surrender it to the precinct, and this is a factual question that should have been given to the jury. And there is ample case law from the Court of Appeals going back decades that says that where there is defense evidence or testimony that is perhaps incompatible with the defense being asserted, it's still not the judge's job to deprive the jury of the opportunity to weigh that. And if you think about it, it's not all that you could compare it to a defense motion to dismiss charges, a trial order of dismissal at the end of the case. Viewing the prosecution's witnesses may be inconsistent in some regards, but if you view the evidence in the light most favorable to the prosecution, the case ultimately goes to the jury. And here the charge has to go to the jury in this circumstance, and the Court of Appeals has been very clear on this in a number of different contexts. And I think what's really important here is the judge admittedly was weighing evidence. He was looking at inconsistencies in Mr. Jackson's testimony and in other evidence and deciding the ultimate issue. He was deciding.
Well, this is Judge Scarpullo. What do you mean admittedly? You're saying that the prosecution admits that that's what the judge did?
No, I'm sorry.
That's not admittedly.
I misspoke. What I meant to say, well, first of all, I'd actually note that the prosecutor here did admit that the charge should be given initially twice. On pages 439 and 444 of the record, the prosecutor said, I think viewed in the light most favorable, the defense should get this charge. And then the trial judge talked the prosecutor out of it, which was grossly improper, but we're not arguing that here right now. So the state did actually concede that the charge should be given twice, not once.
But it's the determination of the court as to whether the charge should be given or not. I mean, obviously, if there's a request to charge, the court has a discretion based upon what the law and what the court believes the evidence shows as to whether or not that charge should or should not be given.
Absolutely, Judge. And I think the other point that I meant to make, though, was that the judge was admittedly weighing credibility. The judge was looking at inconsistencies in Mr. Jackson's testimony and discarding parts of that testimony. And the state uses the word weigh a part of Mr. Jackson's testimony. That is a classic job for the jury, not for the judge. And the Court of Appeals.
We have 2 minutes on rebuttal. People.
Thank you.
May it please the court, my name is Alice Wiseman. I'm appearing on behalf of the respondent. Your Honors, in fact, the trial judge here was correct in his determination that there was no reasonable view of the evidence, including any of defendant's testimony, viewing it in the light most favorable to the defense that would have supported the defense here.
Well, Ms. Wiseman, there seems to be a discrepancy, which I don't understand. My understanding was that the defendant did, in fact, testify that he stated to the police to the police officer that he was either going to take it to the precinct or he was going to dispose of the weapon, either throw it in the garbage or in the river. So what exactly was the defendant's testimony at trial?
So, Judge, first of all, the defendant's pretrial statement was made to a prosecutor, and in that statement, in which he admitted taking possession or having possession of the gun without Jones's knowledge and keeping it in the apartment, in that statement, he said that when he left the apartment the day of his arrest, he intended to either take it to the police or throw it in the river or toss it in the garbage. At trial, he testified initially that he intended either to take it to the police or throw it in the river. When the prosecutor cross-examined him about the statement about throwing in the garbage, he implicitly, he didn't say, no, that wasn't true, unlike a lot of other things in his statement. Instead, he tried to justify the throwing it in the garbage by saying, well, if he did that, he couldn't be arrested for the gun. In other words, the explanation he gave at trial for what he was purportedly going to do when he left the apartment with the gun was to get it away from him so that he couldn't be at fault. Nothing about having an intention of rendering the gun safe or giving it to the authorities.
But
So
the
I think
trial
on that
testimony,
ground alone,
but his trial testimony was also that he was either going to take it to a precinct or that he was going to dispose of it.
to throw it in the river, yes, Judge. The garbage specifically, he initially said in the statement, but then on cross-examination, he essentially adopted that. He didn't challenge that that was also a possibility in his mind. And as I say, he justified it by, let me just find the page. He justified it by saying that he wanted to not be arrested with the gun. Backing up just to the beginning of this, and it is certainly agreed that the gun came into the apartment without either the witness, Jones, or the defendant knowing that there was a gun in this box. When they discovered it, and again, just looking at the defendant's testimony, he said Jones told him to put it in the closet, and then the defendant, put the loaded gun in the closet. She said that at some point she would contact her friend and get rid of it. And he claims he then did nothing else at that point to get rid of the gun. Now, regardless of whether, obviously, Jones had a responsibility to get rid of that gun as well, but that is not the issue when it comes to temporary lawful possession. He's essentially living in this apartment. He obviously has access to the closet where he placed the gun and knows it. So I think any inference is already negated simply by the fact that he doesn't do anything about it. Then, several weeks before his arrest, after some months have passed, he testifies that he sees the box the gun was in, and that he was surprised at that point because he assumed that Jones had given the gun to her friend. So at that point, again, there's some question. He doesn't say he saw the gun in the box, but I think it's clear if you read the context of his examination, they're not talking about, oh, I was surprised to see the empty box. Obviously, at that point, he knows there's a gun. He still does nothing. He then testifies at trial that he woke up that morning thinking, gee, today's, the day I'm going to get rid of this gun and do something with it. So at that point, again, he himself has admitted, you know what, I knew there was a gun in the apartment. I could have gotten rid of it. I didn't do anything about it. Again, that negates any possibility. That's inconsistent with temporary lawful possession. And finally, the one thing.
Counsel, any significance to your adversary's argument that the people, at least on 2 occasions, stated that it was their belief that the charge should be given?
I don't think so, Judge. I mean, honestly, there's a lengthy discussion about this. I think initially the trial prosecutor may not have been fully familiar with the law. He didn't simply change his mind because the judge convinced him to. He went back, as he said, and consulted with his supervisors and came to the conclusion that, in fact, the charge was not supported. So I don't think that's any kind of, and that was our ultimate position, and that was the judge's independent conclusion. So I don't think there's
also your adversary made reference to the fact that his actual possession, once he left the apartment, was fleeting. He stated that the defendant was arrested almost immediately from when he actually left the apartment.
I would say it was soon after he left the apartment. He left the apartment. He walked down a walkway. He spoke with the complainant's for his girlfriend's brother, who happened to be in the location. The police then approached, according to the defendant, an officer asked him something like, "Hey, what's up?" He didn't say anything at that point. I do want to address one thing because the defendant is repeatedly saying that the one piece of testimony that the defendant gave that could even argue that he is pointing to suggest that the jury could have found that the defendant only knew the gun was there, right before he left the apartment, is a statement that he claimed that his girlfriend took the box out, opened it up, and he saw the gun was there. He didn't say he was surprised to see the gun there. He didn't say, "Oh my gosh, until that moment, I did not know the gun was there." He never testified to that. So especially given all of his other direct testimony that showed knowledge the gun was there is in fact nothing. I mean, I think the judge is right. Obviously, his testimony is all over the map, but there is nothing that would have supported the defense in defendant's own testimony, and of course, nothing in the people's testimony. So, therefore, there was no basis to give this charge. I would also just point out that even if there had been a basis to give the charge, I think there's no reasonable jury would have credited it in light of, then if you start looking at credibility, then you look at the defendant's statement that was made in detail where he admitted, he was the one who said he'd take care of the gun. He was the one who put it in the closet and loaded it and put it in the closet, admitting to things, that he didn't have to, just admitted that he contradicted a lot of his trial testimony. So even if this had in fact been a credibility issue for the jury on this, any mistake would have been harmless simply because the jury would not have credited that on these facts. However, I think it is clear the trial judge was correct. He was not usurping the province of the jury when he simply looked at what the defendant said and said, you know what, this person has not said anything to support this defense. And again, the defense isn't just, did he come in possession of it in a lawful manner? The question is, there's a temporary, transitory element to it. You have to then take the first opportunity to dispose of the gun by giving it to the authorities or otherwise disposing of it safely. He never even testified that that was what he intended. He just wanted to get, at some point, months later, wanted to get the gun away from him, even if he did so in a manner that, in fact, might have been dangerous, or it might have been found by a child or a criminal or something. So I think for all these reasons, the reasons stated in our brief, there was no basis to give the charge. Are there any other questions from the court? I just want to mention one thing, as I know my adversary has rebuttal time. There was a question from the jury in a jury note about this charge. I don't think that does not have any significance here. It was discussed during voir dire. The judge gave a preview of it. He suggested, you might hear about this. Understandably, then, when the jury didn't get the charge after they asked about the charge, and the judge explained to them without objection from the defense that the legal issue did not arise. And so I don't think that affects anything in this case. If there are no further questions, thank you, Your Honor.
Your time is up. Thank you. Yes, Mr. Bernstein, you have 2 minutes.
Thank you, Judge. A couple of quick points. With regard to what Mr. Jackson's affirmative testimony was when he about his intentions, if you look at page 338 of the record, he says, "I was going to leave the apartment, go get into the car, and drive it to the precinct, the nearest precinct." So that was his testimony about that. Now, he did, in being asked about his pretrial statement, he did talk about that was where he had said something about disposing of it in some other way. But his testimony was he intended to surrender it at the precinct. Another important part of the record I just want to point you to is my adversary talks about saying there's nothing in Mr. Jackson's testimony about his expressing surprise, but that's not true either. On page 335 of the record, he says, when Ms. Jones opened the box with the key, once she did, I realized, I saw that the gun was still in there. So look, it doesn't have to be the clearest thing. There needs to be proof in the record. That is what the Court of Appeals has said. And there was proof in the record here. It's up to the jury to decide what to do with that.
But that contradicts his own testimony that on that day, he was going to turn it in, right?
It absolutely does, Judge. But
last night, I spent the night thinking about it, and I said, tomorrow I'm turning that gun in. So he couldn't have been surprised that the gun was there.
But these are inconsistencies that it's the jury's job to resolve. And that again, the Court of Appeals has said where there are inconsistent parts of a defense's case, that's the jury's job. You give the charge, the jury may not accept that, but it's the jury's job to weigh it. And I think with regard to the question of the jury note, I mean, I think that proves that this was not a harmless error, because the jury here acquitted Mr. Jackson of 3 counts. It was skeptical of Ms. Jones's testimony, and then it asks questions about this defense. And then once the judge charges them that this is no longer a defense in the case, the next note they give has a question about whether possession is determined by time. They're still focused on this. So I think it's hard to argue that this was a harmless error. And just very briefly, there is an Orama issue in this case.
Well, very briefly, I'm sorry, counsel, your time is up, but thank you.
Thank you.
Hindland versus Advanced Alternative.
Well, Your Honor, this is Mark Zauderer for respondent. I'm here just to confirm.
I know. Do we get the appellant back, or is the appellant now here? Let's see if we can reach out. Hello? Appellant? They didn't answer on the calendar call, but I believe they answered when Ms. Rojas. Mrs. Zauderer, did they answer when Ms. Rojas spoke?
Yes, I heard him. I didn't see him. I think he was unable to get in a visual connection or something like that. But I have not heard from him since.
Okay, let's call the next case and then we'll come right back to you, Mr. Zauderer.
Thank you, Your Honor.
Okay. Golden versus Levy. No one's here today. Golden versus.
No. I had muted myself, Your Honor. I'm sorry.
Okay.
Can you hear and see me now?
Yes, gotcha. Nice background.
Very good.
Nice clear blue background. I like that.
Thank you. Thank you. I take pride in my production values. Okay. Good afternoon, members of the panel. Peter M. Levine, counsel for the appellant Laura Golden. The IAS court disregarded the party's stipulation of settlement when allocating Laura Golden's Random House 401k. The decree of the IAS court that the respondent, Matthew Levy, is to receive 50% of the appreciation on 100% of the marital portion must be reversed. When properly read, the stipulation of settlement allocates to Levy 50% of the appreciation on 25% of the marital portion. And there are good reasons for this, all as explained in the stipulation itself. Levy agreed to receive only 25% of the marital portion to account for his invasion and dissipation of his own once substantial retirement accounts and for cashing in his life insurance policy without his wife's knowledge and consent.
Doesn't it, in fact, when it's referring to the 25%, isn't it referring to the appreciation and depreciation rather than the actual corpus itself?
Correct, exactly. It's 25%. It says he receives 50% of the passive appreciation, quote, pursuant to the formula set forth in Majauskis versus Majauskis. And the IAS court disregarded the party's manifest intent and absolved Levy from the agreed consequence of betraying his wife's and his family's welfare. Let's turn to page 84 of the record to see how the stipulation actually allocates Laura Golden's Random House 401k. The corpus, the marital portion, is set at $251,586. Levy receives 25% of the marital portion, or $62,897. In addition, he receives either the appreciation or depreciation, and there's no dispute that there was only appreciation. He receives 50% of the passive appreciation, quote, pursuant to the formula set forth in Majauskis versus Majauskis, close quote. The stipulation could not have been more clear. The Majauskis formula was to be used to compute Levy's percentage allocation of the appreciation, and then Levy was to receive 50% of that percentage. The IAS court made no effort at all to follow the methodology mandated by Majauskis. Instead, the IAS court rewrote the stipulation with the arbitrary decree that Levy would receive 50% of the appreciation on the entire 100% of the marital portion, instead of only 25% of the marital portion allocated to him. He was to receive appreciation, according to the IAS court, on $251,586 instead of $62,897. And by ignoring the plain language of the stipulation, the IAS court awarded to Levy appreciation on an asset he did not own, on an asset he could not claim. The IAS court sought to justify that arbitrary revision with the bald declaration, quote, "This is consistent with the holding in Majauskis," close quote. No, it isn't. It is not consistent at all. The IAS court nowhere explained how the application of the Majauskis formula could possibly lead to Levy receiving 50% of the appreciation on the full, on 100% of the marital portion. The decision in order of the IAS court is totally silent on that point. The IAS court did not consider the number of months Laura Golden and Matthew Levy had been married while she accrued retirement benefits at Random House. The IAS court did not consider the total number of months Laura Golden had accrued retirement benefits while she was employed at Random House. And the IAS court did not consider whether there should be an adjustment to the standard 50-50 Majauskis percentage allocation to assure an equitable distribution of the appreciation. The Majauskis case and its progeny require that each of these elements be factored into that decision. We go step by step at pages 52 and 53 of the main brief. We go step by step through that calculation, and we show that Levy's share under the traditional 50-50 percentage allocation comes to 35.8. The party stipulation of settlement mandates that Levy receive 1/2 of that, or 17.9%. But in addition, following Majauskis, going to step number 2 of the Majauskis analysis, there must be a downward adjustment to account for Levy's lack of contribution to the marriage in general and to the 401k in particular. There must be an adjustment to account for the loss of his many jobs, the dramatic decline in his income, the tax penalties he accrued, the civil judgments he incurred, the seizure of the couple's personal property as a result of his conduct. We contend in the main brief that a 1/3 downward adjustment, which is consistent with the case law, would be appropriate. That brings Levy's share to 11.9%. Now, Laura Golden contended in the IAS court, and she contends here that the percentage that should have been allowed to Levy was 12.5%, 50% of the appreciation on 25% of the marital portion. And this contention is consistent with the clear language of the stipulation. Levy receives appreciation only on the share of the marital portion allocated to him. And what's interesting here is that the parties agree on such a treatment for Laura Golden's other 2 retirement accounts. They agree appreciation only on the portion allocated to Levy with respect to the Random House pension plan and with respect to the Morrison and Forster 401k plan. So
Thank
when
you,
we
Counselor.
apply...
You have 2 minutes in rebuttal. Counsel for
Okay.
Levy?
Good afternoon, Your Honors. My name is Jennifer Cohen-Vigdor, Brian D. Perskin and Associates. I'm here for the defendant respondent, Matthew Levy.
So did the IAS court defer or not consider Mazukas?
The IAS court absolutely considered Majauskas.
Thank you.
The IAS court absolutely considered Majauskas versus Majauskas. In fact, the formula that appellant refers to in Majauskas is very simple. There's not some sort of complex formula, and there's certainly nothing in the Majauskas decision that provides a formula for reductions for questions of fact, as appellant is arguing. But the Majauskas formula is very, very simple. It's one line. It is as follows: 50% of the marital portion of the retirement account. And the marital portion is defined as years of service credit accrued during the marriage divided by total service credit at the time of retirement. And that's the whole Majauskas formula. Now, of course, people are free the parties were free, and anyone is free in their stipulation of settlement to use some amount or portion an account an amount other than 50%, which is what the parties did here. In fact, the treatment of all three accounts is different. Not one of them is treated the same, the three accounts in the stipulation of settlement. So it's very difficult to look at the other accounts as they were divided and say that that proves some intent for this account. What we know about this account.
So I understand your position is that the stipulation did reduce the proceeds to 25%, but it had no impact whatsoever on the appreciation or depreciation. It didn't have any language saying that affected the appreciation or depreciation. Is that?
I would phrase it a little differently. I would say that our position is that the entitlement was to 25% of the marital portion as it existed at the date of commencement, which is the number that Mr. Levine cited. But then it did include 50% of all appreciation and depreciation of the marital portion of the account. I don't see how it can be read any other way, especially because if you looked with the Majauskas reference in that provision, if you look at Majauskas, and Majauskas is about a 50% division, I don't see how, if her intent was for the respondent to only receive 12.5%, it wouldn't have very clearly and explicitly said he's to receive 12.5%. Because Majauskas talks about 50%, the reference to Majauskas, if anything, would go the other way, would mean that, yes, we would presume a 50% division of the appreciation depreciation. And if there had been another intent, particularly where it involves so much money, it would have been stated very clearly. And that's why the IAS court reached the decision that it reached, because it's very clear.
Are we using the same formula as to the Morrison and Forster retirement plan?
No, we're not. Each retirement plan had a different scheme in the stipulation of settlement. And if you look at the entire body of the stipulation of settlement, you will see many economic trade-offs all over the place. And in many cases, not even explained why they exist. Just some certains owed here, you get this lump sum amount there. So there were a lot of trade-offs, and this was done years ago. But there were many, many trade-offs. There was a lot of horse trading, if you will, that happened in this agreement.
So we're looking at each separately, is that correct?
Yes.
You have to look, and the agreement looks at each separately, is that correct?
The agreement looks at each account separately? Is that what you're asking? Yes, the agreement does look at each account separately.
Thank you.
Quickly address, I wanted to also just address some of the other issues that were raised on appeal. The question of whether the trial court erred in failing to make an award of partial summary judgment. I want to note that partial summary judgment was never sought by the appellant before the IAS court. She never brought a motion pursuant to CPLR section 3212, which would have required her to demonstrate that there is no defense to the cause of action or that the cause of action or defense has no merit. Because she never brought such a motion before the court never understood that she was seeking a summary judgment or partial summary judgment, and hence could not have possibly ordered summary judgment. I think the case law is clear that that a motion is required, and even on the respondents, excuse me, even on the appellant's reply brief, the case cited there involves a motion for summary judgment. So I don't think that that there's a question of whether the court even could have just sua sponte ordered partial summary judgment. Then there's questions raised about whether or not the respondent made admissions to owing some certain. We contend that he did not make admissions. There were settlement discussions. One such settlement discussion was included, attached, or one such settlement letter, excuse me, was attached to a motion. The fact that it was attached to the motion does not defeat the protection of CPLR 4547.
Counselor, Justice Scarpula has a question.
I'm just, so your position is, you're looking at your notes so carefully, I don't think you heard me.
I'm sorry.
Your position is that you dispute the amount of add-on arrears and that a hearing was necessary, right?
Absolutely. A hearing is absolutely necessary.
And
there
whether
are
or
so
not
many
it was
questions.
willful.
I'm sorry?
And whether or not it was willful not to pay those add-on arrears.
Absolutely. There are many questions of fact here. The IAS court acknowledged even early on, there are minutes that are attached to the record, that there was all this voluminous documentation. It didn't seem at all clear to the court what it meant. There were attempts at clarification later on. Some things were able to be worked out. That's actually why the respondent made one payment of undisputed amounts in excess of $29,000. And even a very important point is that when the second motion for arrears was made, there were two motions. There was the original order to show cause that also sought contempt, and then there was a second motion. When that second motion was made, and they're seeking counsel fees on that motion, none of those expenses had been submitted to Mr. Levy prior to the receipt of that motion. So there's even a question of whether you would be entitled to counsel fees when no one had ever asked for the money or submitted any documentation in connection with seeking reimbursement.
Thank you, Counselor. Your time is up. Mr. Levine?
Thank you, Your Honor. I did not hear an answer to your question, Justice Weber, about where in the decision in order the IAS court went through the Majauskis formula, and there's a good reason there was no answer, because the IAS court did not go through the Majauskis formula at all. It's just not there. Under Majauskis, you look at the number of months accruing benefits while married divided by the total number of months accruing the benefit, and then engage in an equitable adjustment. And in fact, that's exactly what the Majauskis case did. They had the fraction, divided that fraction in half, and then the court said, well, the wife wasn't married to the husband for all that long, and we're going to cut that by 1/3. Nothing like that happened with the IAS court. In the IAS court, the Majauskis was totally ignored. As for the other two accounts, in contrast to the Random House 401k, the other two accounts just say he gets passive appreciation. No percentages specified at all. So if everyone's agreeing that Levy gets appreciation on the portion of on the share of the marital portion allocated to him, for those two accounts, that means he gets 1/2 of the rate for the Random House 401k, because for the 401k, it's explicitly stated 50%. Now, with regard to Levy's admissions, Laura Golden sought $93,730 with her two motions. He agreed. He's admitted owing to $77,788. And we could see his admissions clearly on the record. We could see it clearly on the record. Turn to page 967. We see his check in the amount of $29,584. Turn to page 1,865. We see his admission We see the stipulation of October 18th, 2018, in which he admitted owing his full 40% share of the son's college tuition, $47,928. Turn to pages 1839 to 41. We see Levy's confirmation of that admission a year later with his own chart analyzing the son's college tuition, which he submitted, a chart he submitted to the IAS court under a sworn affidavit.
Counsel, this is Judge Scarpula. Are you saying there's no dispute as to the amount?
Correct, based on his own admissions. He admitted in his own charts, if you look at pages 1755 to 57, he has his own chart analyzing the add-on arrears, the second motion. He goes line by line through Laura Golden's claims, and he puts a Y for yes or an N for no about what he claims he owes. If
Well,
you
if
add up
there's
all
an
the
N for no, why would there be agreement?
No, I'm saying that there's agreement on what he admits on the yeses. He admits on the second motion owing $25,000.
Counsel, how are you aggrieved by having to just do a hearing with respect to the what he's not admitting to, and then entering one?
He's not admitting to negligible amounts, and Laura Golden cannot be consigned, cannot be condemned to endless process. What is the point of having a hearing? The referee will confirm Levy's admissions. Yes, you admit to owing $77,998 of the $93,000 thousand claimed. What's the point of that? He should be ordered to pay exactly what he admits owing right now. Why should she have to wait? There's not an issue of credibility here. And the amount in dispute is about $15,000, and $12,500 of that is medical expenses. And he says, I don't have to pay the medical expenses because my prior consent was not obtained. But his prior consent was not at all required for the psychiatric services, and that accounts for $7,940, 63%. So we have a real controversy, if in fact there is, over $4,722.
Thank you, Counselor. Thank you very much. We have your briefs. Thank you. The next matter, we're going to go back to Hindlin. We'll try this again.
Thank you.
Are you here now?
Yeah, I am. Thank you, Your Honor.
Oh, you're quite welcome.
I apologize to the court and to Mr. Zotterer. I had checked out with Ms. Rojas just fine, and then all of a sudden, when I tried to respond to the calendar call, nobody was hearing me. So, well, that may happen to me time.
We can hear you now. You may proceed.
Thank you very much. There's no waiver as a result of the 2010 waiver document. And that's found at 204 to 206 of the appendix. By its terms, the waiver facially applies just to the 2010 agreement. The 2014 co-publishing agreement is not an amendment to the earlier agreement, but it's a new agreement. What was amended, the first 2010 agreement was a single document. There was an amendment to that single document in 2014 of 2 pages. That 2-page document says explicitly that the co-publishing terms of the 2010 document do not apply, and goes on to changes as to the production agreement. And there is a completely separate and new producer and new co-publishing agreement in 2014, and that's at pages 57 through 88 of the record. And there is a significant substantive difference between the two. The 2010 agreement did not have what's called an MDRC, essentially, which is a minimum requirement to satisfy a term. And it was purely based on time passing and repayment of certain advances. Conversely to that, the 2014 agreement specifically includes within it, at pages 61 and 62 of the record, a minimum delivery requirement which has to be satisfied for a term to be deemed over and go on to the next term. It was that issue, that MDRC issue, that Mr. Bevin placed himself in between Mr. Hinlin and prescription. And so that the issue, which is at the core of the lawsuit, was not subject to, was not known of, was not even thought about at the time that the waiver was signed. Now, we either there's a cause of action in tort or a cause of action in contract, and agreed not both. We pled in tort because, in our view, the agreement does not unambiguously address the subsequent obligation assumed by AAM to resolve the MDRC problem. The court below held, however, that it does unambiguously cover that area. Well, if that's so, then the cause of action should have been allowed to proceed as a contract action. 3211A7 fails if the facts as alleged fit into any theory. That's this court's decision in McGill v. Parker and the Court of Appeals in Guggenheimer v. Ginsburg. Here, the elements of a breach of contract are all pled. The existence of a contract is pled at paragraph 128 of the amended complaint at appendix page 135, and paragraph 130 of the amended complaint, page 21, page 136 of the appendix. So that's the existence of the contract. The second element, breach by defendant, is pled at paragraphs 131 to 135 of the amended complaint at page 21.
Counsel, this is Judge Kern. Is that part of your appeal? I don't understand part of your appeal to be an appeal of any determination dismissing any contract claim. My understanding is that you were appealing the dismissal of the negligence and breach of fiduciary duty claim, and that's the only issue before us, not an appeal of any dismissal of a breach of contract claim. So I'm totally confused by the argument you're making right now.
Okay, so what we're saying, Judge, is we pled the tort claim because we didn't believe the contract unambiguously addressed the subsequent assumption of the obligation.
But if you didn't plead a breach of contract claim, how can we possibly address the breach of contract claim? The only claim we have before us is the tort, the negligence claim. So you would have to establish that the agreement did not cover your claim, and the agreement is unbelievably broad in terms of what it does and does not cover. It's all aspects of his career in all ways. So I don't know how you could possibly argue that this would not be covered by the agreement. So either you have a breach of contract claim that you're asserting or you don't.
Well, and Your Honor, in Guggenheimer v. Ginsburg and this court in McGill v. Parker came out to the opposite conclusion. Both those courts say you look to see at the facts whether whether a cause of action has been pled, not what the label is. And if you go through our complaint, if the holding of the lower court that the clause unambiguously takes into account an obligation assumed, 5 years later.
Counsel, this is Judge Karkula. Yeah, did you argue below that you pled and that you pled a breach of contract claim?
No, because there was.
So then how are you arguing it on appeal if you didn't argue it below?
Because below, the whole focus by everybody was on tort. And the first
so you haven't given the other side any opportunity to even, or the trial court to even consider that argument. So we can't consider it here on appeal if you didn't argue it below. Let's focus on what you actually argued below.
We did ask for leave to amend if the motion was to be granted.
Did you attach a proposed amended complaint with a breach of contract claim?
No.
Okay.
No.
So let's talk about what you actually argued.
We can only.
Counsel, you're out of time, actually, and you haven't really gotten to the gist of what your appeal is. So, I mean, I'll give you an additional 2 minutes because I'd really like to hear what your argument is in terms of the negligence and the breach of fiduciary claims.
Okay. The breach of fiduciary duty arises from the relationship of a manager, agent to his principal. That's established in Tyson v. Caton, Southern District, and this court in Gershinoff v. Panoff. We argue that at pages 37 of
Counsel,
page
this
37
is
of our brief.
let me go back to what I earlier asked you then. The management agreement here says advise and counsel on all aspects of his career and to act as plaintiff's sole and exclusive manager with regard to activities and interests in any way connected with or pertinent to the entertainment industry. That is extremely broad. How could any of these claims not be encompassed by that language, which would knock out your breach of fiduciary duty and negligence claim?
Because the responsibilities do not include any enforcement on the contract.
No.
They do not include any ability to negotiate with, to enforce a contract which he's entered into. And the sole grant of authority is to advise and counsel the plaintiff as to the various aspects of his career.
It says all activities and interests in any way connected with the entertainment industry and related fields. Sole and exclusive personal manager.
Yeah, but it also is preceded by the words advise and counsel as to, not to enforce. And I respectfully, and I will turn to page 193, where the agreement is located. And
so you're taking the words advise and counsel to mean that, again, that there's some other there's some other responsibilities by plaintiff, by the defendant, which they did not do, right? They did not fulfill.
What I'm saying is that they assumed a separate obligation apart from the contract in 2015, 6 years after the management agreement. And that separate obligation.
I'm sorry, counsel, I allowed you, additional time. So, Mr. Zouder.
Thank you. Good afternoon. Mark Zouder for the respondent. I just wanted to say that when I learned about all these hit songs that were involved here, I realized that I've been out of the culture because my music education began with doo-wop and ended with the Beatles. But in any case, there are...
That's awful. That's really bad, Mr. Zouder.
Look, I think the court has grasped the heart of the issue here. The central issue is whether these activities that are involved in contract fulfillment didn't come within the scope of the agreement. I could spend all of my 4 minutes left going through the services that the court has picked up on, and so did the court below. And to answer the specific reference to page 194 of the record that counsel just made, on page 194, where we talk about the services, if you look upon subdivision G, it talks about dealings with third parties. Counsel says, well, everything is cabined by the concept of to advise and counsel. Well, if I'm dealing with third parties for somebody or dealing and counseling, and I call the third party specifically as here, where the record shows Hindlin specifically requested that AAM deal with prescription, it's obviously within the scope of the agreement. There was no revised agreement for compensation for doing this that's outside of the management agreement that the parties are talking about. And the only exception on the proposition that a negligence or tort claim cannot be asserted where there's a contract claim covering the matter is the so-called Summer exception, SOMMER, which is the fire alarm case, which we could talk about at great length, but I don't have time. But that's all covered in the brief. The conflict issue, it's a pseudo issue, as the judge found, because first of all, we're not talking about lawyers. Each party had lawyers here in terms of the fulfillment issue. They had lawyers, their own lawyers. Inland had his own lawyer in connection with the negotiation of the 2010 agreement. The waiver letter is very clear that AAM has been requested by Hindlin to participate in these business discussions, which it also reflects that Hinlin knew, because it's reflected in the letter, that prescription principal was an existing client of AAM.
Well, that's what I was going to ask. I was going to ask, does not the documentary evidence actually show that Hinlin was aware of the conflict?
Correct. That's right, Your Honor. Absolutely so. And then the course of conduct followed that with full awareness by Hinlin.
What about the argument, Mr. Sauter, that the appellant makes that this is a separate contract, that is not an extension of the 2010 contract? Therefore, in this particular agreement, he didn't waive any conflict.
So to answer that question, Your Honor, if you go to page 57 of the record, this is the so-called new agreement. But if you look at the whereas clause, the last whereas clause says as follows, quote, the parties hereto acknowledge and agree that this agreement shall amend the prior prescription agreement to the extent applicable. So there was some new terms that yes, it's technically a new agreement, but the parties had already established a waiver, a knowing waiver, in the sense you can't unring the bell. And I guess, you could theoretically have a situation where you could revoke it, but this is merely an amendment of an agreement that extended their relationship with some terms that changed. I have nothing further unless the court has any questions.
Any additional questions?
No questions.
Thank you.
Thank you.
Counselor, yes, you have 3 minutes on rebuttal.
Okay, thank you. What the plaintiff did not know about was AAM assuming from plaintiff's lawyers the negotiation of the issue on which there was direct conflict between prescription's interests and Mr. Hinlin's interests that did not exist in 2010 when the waiver was done. And so there is not a knowing waiver in terms of whether it's an extension or an agreement. Looking at the substance and not the verbiage, the substance just eschews the entire former publishing agreement. That's in paragraph 1.
I'm not sure what you're referring to. What are you referring to as verbiage? I thought it was all part of the substance of the agreement.
There were 2 separate agreements, Your Honor. There was one in 2010. There were 2 in 2014. The first one in 2014 is 2 pages, and it's at 855 of the appendix. Paragraph 1 of that document says paragraphs 1 through 11 of the co-publishing portion of the agreement shall not apply to compositions written, composed, acquired, or created by you on or after the date hereof. Instead, the terms set forth in the prescription agreement shall apply to such compositions. And the changes were major. As I said, it went right from a time-based satisfaction to a production, a number of songs satisfaction of a term. In terms of enforcement versus advising counsel, because the advising counsel language comes at the beginning of that paragraph, it seems to us that it is at least ambiguous, which is all we need to demonstrate, that it is at least ambiguous as to whether that advising counsel limitation applies across the board to each of the following items.
Thank you, Counselor. Your time is up. Thank you very much.
Thank you. Thank you.
Next matter is 2157 ACP versus Famous Industries.
Yes, this is Joseph Altman. I represent the appellant of Famous Industries, the defendant in the lawsuit. We're seeking to have summary judgment granted in favor of the appellant, the seller of the property. We believe the decision of the court below, although correctly denying the plaintiff's motion for summary judgment, should have granted summary judgment for the defendant seller. There really are no tribal issues of fact. The contract is clear. In fact, the plaintiff buyer in his pleading says on paragraph 15 that he was ready, able, and willing to purchase the property.
So is this a commitment? Is this a commitment letter?
No, Your Honor.
And why is it not a commitment letter? Although it says it, why is it not?
Well, because we're talking about the one from Corbin, correct?
Yes.
Okay. Number one, it says there are proposed terms, so we don't know what the terms actually are going to be. Number two, in order for it to be an actual commitment, the buyer had to sign it and send it back and pay $50,000 as a commitment fee. So it was never binding on the date it was issued, and we believe that it was done only for the purposes of trying to avoid their own default. It says.
Counsel, when you rejected the commitment letter that says it's a commitment letter and has all the terms of the loan in it, what reason did you give to below in your rejection? Why did you say it wasn't good?
Well, Your Honor, I didn't know that they didn't pay the $50,000.
I'm just asking you, what did you say was wrong with the commitment letter? In your letter saying, I reject this commitment letter, what did you say was wrong with it?
Well, again, I don't believe I detailed every error with the commitment letter.
Did you detail any error in your letter at all?
We just said it wasn't a commitment letter. It's not my responsibility.
Without explaining why you thought it wasn't, even though it does say the words commitment letter, even though that every term that a normal lender would have is in that letter, you send a letter back that says, this isn't a commitment letter. I'm not going to tell you why I don't think it is. I reject it. But anyway, you should pay the $50,000. That's your position?
No, Your Honor. Our position is if they went to closing on the 13th of June, as they had promised, that they said they were ready, able, and willing to go to closing on, they would not be able to close because they didn't have the funding for this transaction.
Counsel, I was going to say, from what you just said before Justice Scarpulla's question, it seems to me that if they had sent that commitment letter with a check, you would have accepted it.
No, Your Honor. Number one, or number two, when you read the commitment, it doesn't say they're going to lend unequivocally $10 million. It says we will consider whether it's going to be $14,500,000 or the lesser of 70% of the as-is value. So a commitment letter, in order for it to be a commitment letter pursuant to the terms of the contract, would have to be an unconditional promise to lend at least $10 million. And there's nothing in this document that says.
Is there any responsibility on your part, or was there any responsibility on your part to at least state why you were rejecting it? Why you were rejecting it as a commitment letter?
No, Your Honor, there's nothing in the contract that says that. I thought it was pretty clear on its face because, number one, it says we will consider. Number two, it wasn't a commitment letter for $10 million. That's what I thought I was saying because it wasn't a commitment for $10 million.
Well, it's a commitment, counsel. This is Judge Scarpulla. It's a commitment for $14 million or the as-is value. And your position is that the as-is value could never be $10 million?
Right.
Why? Why is that your position? Did you put in any documents that show that the as-is value wasn't $10 million?
Well, again, Your Honor, it would have to be something that would be considered by the lender saying the as-is value. We don't even know what as-is value is. So
that's my whole point. So you don't know what that means. You're saying, I don't know if it's 10 million, but it could be 10 million, right? And that's exactly what Judge Hagler said. Could be 10 million. So this could easily fit in. It says it's a commitment letter, has the interest, the terms, all the other stuff that I've seen a million times in a commitment letter. And the only question is, does it come up to 10 million? Well, there's one number that says 14 million, and the other is the lower of as is. So again, I'm going to ask you, do you have any proof that as is value wasn't $10 million?
Well, wasn't that something that the other side, where the plaintiff or the buyer has to come in before the court?
No, you're moving for summary judgment, right? You moved for summary judgment. So you got to prove that this wasn't a commitment letter. And you just told us that it wasn't because it didn't cover the 10 million bucks. And I'm asking you, did you put in any proof about the as-is value?
Again, Your Honor, the
No,
plaintiff.
I'm
in
just,
this
did
case-
you or didn't you?
Because he didn't prove that he had a $10 million commitment.
Okay, but
He didn't
my
prove-
question is, did you, on your summary judgment motion, which is your burden of proof, show that the as-is value wasn't $10 million? That's all I want to know, whether or not you put in that evidence.
The only evidence that we have, Your Honor, is the contract itself, which was $5,700,000, which is the as-is value of this piece of property, because there's no other determination what as-is value could possibly mean. So
Thank you
if
so
look at
much, Counselor. Appreciate it. We have your briefs. Thank you very much. Next case is
Okay,
Vaughn,
well-
2nd Avenue versus First American Title.
Good afternoon, Your Honor. This is Jamie Katz-Sussner with Sills Cummins on behalf of the appellant. May it please the court. The issue before the court is whether an unrecorded historic designation implicates coverage under the respondent's title insurance policy. The answer is a very clear no, it doesn't. It absolutely can't. And the reason is, first, the analysis must begin with whether—
Ms. Judge Kern, can I interrupt? Don't we have to first decide the issue about whether the complaint should have been allowed or not allowed before we get to the merits? Isn't that the first issue that has to be decided? And if it's decided in your favor, do we never get to the merits then?
That's a fair point, Your Honor, and I'm happy to begin there. My hope, of course, was to address both issues, but I'm very happy to begin there because Your Honor's absolutely right. If the complaint must be dismissed because it was untimely, then you're absolutely right. We never do get to the merits. So on that point, I think as the court is aware, the time frame really is not in dispute. This action, of course, was commenced with service of a notice and summons. There was a 4-month delay before the complaint was filed. Before we served notice and demand, by the time that the complaint was actually filed, it was more than 2 months after the complaint was due. The cases construing this issue are absolutely irrefutable. There are 2 prongs that must be satisfied if a late filed complaint, for it to be accepted as untimely. First, there must be a demonstration of a reasonable excuse. And second, there must be a meritorious defense that's supported by an affidavit of merit. In terms of a reasonable excuse, the excuse that was provided here was law office failure. The assertion was, and the verified affidavit stated that an attorney had left and nobody realized that the complaint had not been filed and served. As the cases clearly state, law office failure is not a reasonable excuse, period.
So isn't your other argument stronger about the affidavit of merit, since that's a much more clear-cut issue than what is or is not reasonable excuse?
Well, the truth of the matter, Your Honor, is that both are strong because you need both. Having one or the other is not enough. I'm happy to focus on that. There must be, of course, an affidavit of merit. There was no affidavit of merit. And even if the plaintiffs here, Fawn, were to suggest, well, hey, we have our complaint articulates what our claims are. The complaint was not verified. There is no verified statement of what the cause of action is. There wasn't an affidavit of merit from an expert who's able to opine that there's merit to the claims. There's no enunciation of what the causes of action are, why they're substantiated.
So I know you said this already, but do you agree with the position that if we accept your argument about this, that we should not be addressing the merits in any way, shape, or form?
I do agree that if the complaint is dismissed due to a failure to timely serve, yes, the court need not reach the merits. That's an accurate statement. But in terms of, so if I may just complete the argument in terms of the untimely service, both prongs failed here. In terms of the reasonableness, the case law is actually pretty crystal clear that the trial court cited an absence of prejudice as a reason why the court was prepared to accept a more than 2-month tardy complaint, there's not a single case that I have found where a more than 2-month delay was accepted as an acceptable period of time. All of the cases, and we cite a number of them, where a 2-month delay was unreasonable. Anything more than a few days has been rejected by the courts of this state as being reasonable. So under the standard that governs under 3012B, Fawn fails under both of them. And the court need only find that they failed under one in order to reverse and dismiss. And so it's fairly clear here that to rely upon prejudice as a basis not to follow the very clear dictates of Kell was erroneous. Now, should the court move past that argument? Should the court consider the merits? The case fails on the merits too, which is an important consideration. Here we have a title insurance policy which only covers matters of record. We have a list of coverage provisions that have to be consulted before you even bother getting to whether or not there's an exclusion, because you can't have an exclusion from coverage unless there's coverage in the first place. So a reasonable analysis of the policy is, well, let's begin and see if there's coverage. So beginning at coverage, of course, we look to the complaint, and there's no allegation of any specific coverage provision that actually applies here. So when confronted with a dismissal motion, the respondents identified covered risk number 5. So what does covered risk number 5 say? Covered risk number 5 says that there will be covered if there is a government regulation relating to the character of the property and it is recorded of record. And specifically, it says recorded in the public records, which is a defined term. Under paragraph 1I of the policy, public records is the real property records, just the real property records. It doesn't matter if it's recorded in some agency someplace. What's covered under a title insurance policy is what appears of record, period. Here, this designation was not filed in the land records. It was not. It's not up for debate. It's not alleged in the complaint that there was some document that was recorded and missed by the company. It's not alleged that there's some document floating out there. It's not identified anywhere in the record before this court. And of course, we attached an ACRIS printout, which shows, in case there's any doubt at all, that the reason that the allegation hasn't been made is because there is no document. There is nothing that was recorded. This is a regulatory action. And because the regulatory action was not recorded in the land records under covered risk 5, it simply is not covered under the policy. But even
Thank you, counsel. You have time in rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. Matthew Hurl for the respondent. To address Justice Kern's questions with respect to Justice Engoron granting the cross motion, we suggest that he did not abuse his discretion in permitting the late service of the complaint. At the time, there still is no statute of limitations problem. He was not going to go through the exercise of having a reservice when it was within his discretion to determine that the late service didn't prejudice.
Counsel, that was prejudice the standard. If we're assuming that we have to analyze it in the context of their motion to dismiss based on failure to serve a complaint, prejudice is not really part of the analysis. The analysis is reasonable excuse and an affidavit of merit. And no matter what the reasonable party may or may not disagree about reasonable excuses, no affidavit of merit. It's an unverified complaint. So where does the justice below have the right to do discretion under that standard?
Well, he has the discretion in that the merits were briefed to the extent that they had made a motion on the merits, to which we responded. If the cross motion papers were also the opposition with respect to their motion. So the merits were addressed and before the court in the context of the legal issues regarding the complaint. We did cite cases in our brief where I might, even if I were to agree with Your Honor's premise that the court has no discretion, The third department did specifically in a case that I argued, disregarded what Your Honor is saying and said, look, there's no prejudice. You address the merits. That's good enough. We're not going to exalt form over substance and make you start again when everything is before the court.
How can we ignore the CPLR provision?
Yeah.
I understand that you think it's an exercise in futility, but the CPLR is the CPLR, and if there's a specific provision which does not discuss prejudice, it only discusses reasonable excuse and affidavit of merit, how can we do a prejudice analysis?
Well, Your Honor, it also places everything in the discretion of the court, and I think the discretion of the court does allow it. And I'm just looking for the case just to give you the site that I would ask you to look at.
Well, there may be discretion in terms of the excuse in terms of law office failure. There may be some discretion in that, but how is there any discretion in terms of an affidavit of merit based upon personal knowledge?
Well, with respect to the personal, there's very little personal knowledge here. This is an interpretation of a contract. It's a legal issue. And I would submit that the affirmation that I submitted in support of the motion and in opposition does address the merits of the underlying case. And so I would suggest that there is sufficient evidence that was submitted in this motion sequence to serve or to satisfy the affidavits of merit. The purpose of the affidavit of merit is to present to the court whether this case has any legs. And Justice Engoron determined that it did based on the submissions before him. So I would submit that the affirmation did address the merits, and that should suffice for an affidavit of merits in this context. Now,
in terms, counsel, wait, are you saying an attorney affirmation who has no personal knowledge about what happened is sufficient for an affidavit of merit?
yes, because the questions that are at issue here are not factually, they're not factually specific. We're talking about interpretation of a policy.
Right. So were you there when this policy was signed? Can you affirm that this is the policy at issue? Anything that the complaint would do if it was verified, could you do that?
The policy at issue, that's not disputed, Your Honor. They admit it, we admit it.
The CPLR requires affidavit of person with knowledge. So I'm asking you, you're saying I've got enough knowledge, and I'm asking you knowledge of what?
I have knowledge that this is the policy at issue.
How? How do you have that knowledge?
Because they submitted it in their papers. They said this is the policy. And I didn't disagree. I agree. This is the policy. There's no dispute. You're respectfully, when I think you're creating questions that don't exist.
No, I'm just looking at CPLR 3012B and what it requires, and your argument that you, who weren't there when the document was executed and have no personal knowledge about it, could submit an affidavit of merit. That's all I'm looking at.
Well, no, Your Honor, I would say that the record that was before Your Honors and before Justice Engoron, that was not a question. That is not a question. There's no question of fact as to whether this is the policy.
So it would just seem, therefore, that CPLR 3012B would never apply in cases where you're talking about a policy or a contract, because you would just say it just speaks for itself, and so therefore you wouldn't need any type of affidavit of knowledge.
I'm not saying it that as a blanket statement. I'm saying it in this case, because this case.
But even a blanket statement, it just seems it's an interesting, to some extent, it's just an interesting argument that I don't know whether it's actually supported by any case law. But in terms of the allegations themselves, in terms of landmark status, et cetera, I'll give you 2 minutes to respond to that.
Thank you. With respect to those issues, with the coverage speaks for itself. The coverage in covered risk 5 speaks in terms of coverage as allowed where there's losses or damages for a violation or enforcement of any law, ordinance, permit, government regulation relating to the character of the property. Landmark designation falls within a restriction that relates to the character or use or enjoyment of the property. So we submit that the risk 5 is applicable. Now, counsel has argued, but it wasn't in the public record. That is a fact that is not a fact. That hasn't been established. They submitted some ACRIS report. Justice Engoron said, first of all, that's not documentary evidence. And then he said, there's a question of fact, and we're at the pre-pleading stage. They're saying, oh no, the record establishes there was never a record. That's not true. The record doesn't establish anything of the sort. And so the exclusion is applicable. I'm sorry, the coverage is applicable. The exclusion is not. The exclusion, which reads almost precisely the same as the coverage, which they seem to be contradictory on the first, second, 15th read. But actually what you see the difference is where enforcement and violation is the issue, coverage applies, not the exclusion. And to the extent that they argued, and I realize you've given me more time than I'm entitled to, with respect to the personal knowledge that we read street signs, our brief covers why we think that's a not availing argument.
Thank you. Ms. Sussner?
Thank you, Your Honor. Addressing a couple of points raised by my adversary, even assuming that an attorney could affirm to the merit, it wasn't done here. The only substance in the affidavit that was tendered in opposition to our motion to dismiss spoke to law office failure. There is nothing in there that affirms that the claims are meritorious. There's no effort to do that. Its sole purpose is to speak to the law office failure, which is its own failure. But independent of that, no argument can credibly be made that an affidavit that actually speaks to the merits on any level was introduced here. So even if you accept counsel's argument, that didn't occur. So there cannot be a finding that there was an affidavit of merit here based upon this record. Now, in terms of what was found by the trial court, there is no ambiguity between these terms of coverage and terms of exclusion. First, you find whether there's coverage, then you find whether or not there's an exclusion. Whether or not it's of record is critical. Now here, the reason we know that this fact can't be disputed is first and foremost, their complaint doesn't even allege it. There is no allegation that there's some document of record. There's no allegation. How can there be a disputed fact about something that's not even alleged? But beyond that, even now, even in opposition to our motion where we said, hey, this was not of record, this is not a basis for coverage. There's no document. They still haven't found a document. They've not identified a document, and counsel hasn't argued that there is one. There is no dispute. And by the way, ACRIS is widely accepted, absolutely accepted as documentary proof of what's in the record. That's absolutely admissible. It's accepted by courts all the time. We have a footnote in our brief that the court may take judicial notice of the contents of ACRIS. So it simply is not. The fact that the trial court found a factual issue doesn't mean that that's really what's happening here. And I would also add that where Judge Ergeron erred was he didn't look to the language of the policy. He did not look to the definition of public records, which is really just the land records. What he said instead was he assumed that any record was sufficient. If he had actually considered only the land records, the court could not have possibly reached any conclusion other than this was not of record. This was merely a regulatory action. So for all of those reasons, we firmly believe that the trial court should be reversed. The action should be dismissed. If the court has any other questions, I'm happy to answer them, but I have nothing further and rely on my papers.
Any additional questions? Thank you very much.
Thank you very much.
Next matter for argument is Gamez versus Kew Gardens.
Good afternoon, Your Honors. This is Matthew Cuter for Louis Frisboy. We represent the third-party defendant appellant Alpine Construction. Very simply, Your Honor, the record submitted to the court below plainly establishes that the plaintiff himself was the sole proximate cause of his accident. His own testimony establishes that, first of all, he was provided with a proper safety equipment. He testified that he was provided with a 5-foot ladder that was available to him on the date of the incident, and the 5-foot ladder fit on the landing in front of where this accident happened.
I thought he testified that there wasn't enough leeway for it to actually open out.
Your Honor, the testimony that you're referring to was plaintiff talking about a 6-foot ladder that he had in his hand before the incident happened. He testified that he attempted to open up the 6-foot ladder on the landing, and they said that it didn't fit. That testimony is important for several reasons. First of all, it establishes that plaintiff had a practice of working from ladders in the landing in question. And it also establishes that plaintiff knew he was supposed to be working from a ladder in the landing in question. Plaintiff's other testimony plainly establishes that he said directly, a 5-foot ladder was available to me on the day of the incident. He said directly that the base of the 5-foot ladder requires 2 feet of span to open. He said directly that the landing in question measured 2 feet by 2.5 feet. So the 5-foot ladder, by his own testimony, fit on the landing in question. Now, other people gave more accurate testimony regarding the measurements of the landing, and according to that more accurate testimony, the 6-foot ladder fit as well. But I'm going to focus on the 5-foot ladder since it's undisputed that the 5-foot ladder fit on the landing. Plaintiff also testified that before he began working in any building, he would bring all of his tools and equipment to the building and place them in the basement of that building. So he knew that the 5-foot ladder was available, and he knew exactly where to find it because it was in the basement where he placed it. Plaintiff further testified, as we just discussed, that he knew that he was expected to use a ladder on the landing. And he also directly testified that the boss wanted him to work from the landing. His direct quote was, I believe, well, I'm paraphrasing it, the boss wanted it smooth with the ladder. And despite the 5-foot ladder being available to him, despite him knowing exactly where it was, despite him knowing that his boss wanted him to work from the ladder, he chose to climb onto the windowsill instead, and that directly led to his accident. So from all of plaintiff's own testimony, we've plainly established the test set forth in Oriyama regarding sole proximate cause. I want to move forward, unless your honors have any questions on that analysis. I'm going to move forward to the alternative argument that the hazard in question was not elevation related. And before I get into that, I'm going to address the respondent's argument that I'm not allowed to make alternative arguments. That argument by respondent is based on case law with respect to summary judgment motions and contract actions. The court in those actions said that a movement must choose between remedies of contract remedies and quasi-contract remedies. Here, the remedy is the same, dismissal of the complaint. Plaintiff is allowed to allege alternative theories of liability, and I'm absolutely allowed to allege alternative theories why there is no liability. Now, under the Bragi case, the plaintiff retains the prima facie burden to establish that an elevation-related hazard is involved in a case. Plaintiff admittedly never attempted to establish that in their cross motion. They addressed it for the first time in opposition to the appellant's motions in the lower court. Now, plaintiff plainly testified that
Counsel, Mike Bragi, aren't there factual issues in this case, whether there was a way that this work could have been accomplished without him having to elevate? In that case, it was clear that he could have done the work from the floor. But have you established in this case as a matter of law, this work could have been performed while he was standing on the ground?
So my record on that issue is plainly this. Plaintiff, at one point during his testimony, testified that on some occasions, when he had to scrape from areas that he could not reach standing himself, he would attach his scraper to an extension pole that he had with him. Now, after plaintiff gave that testimony, he attempted to walk it back, and there is some muddied waters there. But plaintiff's testimony initially on that point is clear. It's cited in the brief. Mr. Marcelino, the Alpine witness, testified that the scraper could be attached to an extension pole in a makeshift manner, and defendant's expert testified to that effect as well. So
but I thought that the testimony was that you couldn't use the scraper, or that the scraper was to some extent frowned upon because you would not be able to get the same smoothness with the scraper that you would be able to without the scraper.
Yes, Your Honor. So at one point, plaintiff did mention that, and I discussed that earlier when that was plaintiff's testimony earlier when he said that the boss wanted it smooth with the ladder. That demonstrates that plaintiff knew he was supposed to be working from a ladder. There was no dispute. At some point, plaintiff did say that when Mr. Marcelino was asked. Actually, I'm sorry, Mr. Marcelino did not give any direct testimony. He was not asked if he expected the plaintiffs to work from a ladder. He did not give direct testimony suggesting that the plaintiff could not scrape using an extension pole.
In terms of
attached to the
scraping, what about protective eye gear? Because that was the issue, was it not, that apparently the scrapings, a piece of the scraping, whatever, fell into his eye, which caused him to then fall?
So plaintiff at no point in this lawsuit alleged that he wasn't provided proper eye equipment. No such allegations was made in the bill of particulars. No such alleged industrial code allegations was made. Plaintiff at oral argument, plaintiff counsel at oral argument in the court below said, this brings up a possible motion to amend the complaint. Plaintiff did not move to amend the complaint. The court below properly determined that he would not consider that issue without a written motion, and that issue is not preserved for appeal here. Furthermore, I would say that given that those allegations are not in the complaint or not alleged at any point in time, defendants were deprived of the opportunity to further evaluate those claims at plaintiff's deposition.
Thank you, counsel. You have time on rebuttal.
Thank you, Your Honor.
Your Honors, who goes next, please? Does the other appellant go next, or should I go next for the plaintiff?
That's a good question. Why don't we have the other appellant go first, and then the plaintiff last?
Your Honor, I have submitted.
Oh, okay, thank you. So then you do go next, plaintiff.
Thank you. Good afternoon. There are no issues of fact here in terms of, first of all, it's illogical for the defendants to argue the plaintiff should have used a ladder and then also argue that his work was not elevation related. It clearly was. There's no way he could have reached the top of this windowsill, which was 9 or 10 feet above the ground.
Counsel, what's your response to the argument that a 5-foot ladder would have fit in the landing and was made available to the plaintiff?
While it's true that it was available, the other prong of the law that's applicable which is lacking, and that is there is no proof that the plaintiff knew that he was instructed to use a 5-foot ladder, and the plaintiff clearly testified that he had been doing this work on dozens of buildings of the same configuration. This was a huge complex. Depending upon who testified, there were either 70, 100, or 50 buildings. The plaintiff had been working for months and months doing the same thing, and he never used the 5-foot ladder. There's no testimony that he was instructed to use one, and there's no reasonable inference, given that he was working this way from windowsills, that he knew that he was expected to use one and didn't use one for no good reason of his own. He also had been carrying around the 6-foot ladder, and he realized that he couldn't use that on this landing.
Well,
Also,
counsel, let me interrupt you for a question. Didn't he testify he knew there were other ladders and they were in the basement? He knew they were there. He knew that they were available. He knew he was supposed to use a ladder, correct?
That's the point. There is no proof that he knew that he was supposed to use it. Knowing it's available is not the same as knowing you're supposed to use it. And given the months and months of ratified conduct not using it, I think the proof that he knew that he should have used one is completely lacking. Also, he had worked safely from windowsills for months and months. So why would he assume there was a risk? This was
Counsel,
kind
this
of a
is Judge
freak
Scarpula
occurrence
again.
that this
Isn't there
article fell.
Counsel, this is Judge Scarpula. Isn't there a question of fact actually as to whether or not he was even on the windowsill? There's other evidence in the record that suggests that he flipped over a pail and was standing on the pail.
Well, he had testified that he had stood on the pail to get up to the windowsill. And he also testified that when he fell from the windowsill, he fell to the pail and then to the floor.
And there's a business record that says he was up on the pail and he fell.
Now, whether you just put your finger on another good point, whether that's really a business record is a substantial issue, and the lower court was correct in holding that it wasn't, because it was neither necessary for diagnosis nor was it necessary for treatment. And it's well established.
No, it's not a medical record. It's a business record.
The medical record, I thought said that he was on the ladder.
Right.
The medical record, my recollection was that the medical record said that he was on the ladder. The investigatory report stated that he was on the windowsill, I think. And then they said he was on the bucket. I mean, obviously, we don't know where he was because he's either on the bucket, the windowsill, or the ladder. So I just heard you say that he happened to fall from the windowsill and land on the bucket, which is interesting.
He said that. That's in his testimony. The plaintiff testified to that, and I can give you a reference to that.
That's fine. My point was, it just seems, obviously, we have inconsistent statements as to exactly where he was, but to Justice Scarpula's question, though, he knew that there were other ladders available. And so your argument is that although he knew that there were other ladders available and that this ladder, the ladder that he had, would not accomplish the deed that he was set, the task that he was given, that he would have to have been told specifically to use another ladder as opposed to him seeking out another ladder which would allow him to do the work.
He doesn't have a duty to do anything. He is just a poor day laborer with an 8th grade education. It's the duty of the employer to instruct him and give him, and under the labor law, it's the duty of owners and general contractors to see that workers are given the proper tools under 240 of the labor law and to provide them the proper protection. So the burden is not on plaintiffs.
This is Judge Scarpula. So counsel, that's exactly right. And the employer testifies, we got plenty of ladders. We got 5-foot ladders, we got 6-foot ladders, we got 8-foot ladders. He knows we have all those ladders. He knows that he's supposed to use a ladder to do this work, and he didn't do that. That was the employer's testimony, correct?
I'm not so sure.
Well, I don't know. Let's assume that generally that was the employer's testimony, correct?
Well, the answer is
a situation where there was nothing around.
I can't contradict Your Honor. I mean, that would not be seemly. I couldn't possibly do that. But I'd like to address what Your Honor said in terms of questions of fact arising in accident reports. The admissibility of those reports was established by the lower court to be inadmissible. The admissibility was disestablished because they came from people who weren't witnesses. There was no indication of accuracy of the things recorded in these reports, and they were inconsistent with each other, showing that they couldn't all be right, so that none of them really should have been used to contradict the plaintiffs. So I would argue that nothing in any accident reports
for a second. The fact that a record might contradict testimony is something for a jury to decide. The question is not, that has nothing to do with whether it's admissible. A business record is admissible if it complies with 4518. Medical record is admissible and statements in it if they pertain to treatment or diagnosis, right? So it doesn't matter whether they contradict each other or anything else in the record. That's for the trier of fact way down the line. Do you agree?
I'll concede that for sure. But here the issue is that they were neither certified nor proven to be admissible as business records because their sources were not established. And especially it wasn't established that the source was anyone with real personal actual knowledge. So one of the accident reports was written by an office manager who wasn't anywhere near the place. It's unclear who told her what put in that report. And therefore, the lower court was correct in holding that report not admissible. And if it's not admissible, it's not considering it, it's not creating any issue of fact.
Thank you, Counselor. Mr. Kuder, you have 2 minutes in rebuttal. Muted.
Thank you. Sorry about that. Your Honor, I'll try to be as brief as possible. All of your points regarding the statements in the records were well taken. I'm not going to retread that path. I'm going to address one thing. Counsel indicated that plaintiff's conduct was the result of months of ratified conduct. Mr. Marcelino bluntly testified that he never saw plaintiff performing work from a windowsill, and if he had seen him do that, he would have told plaintiff to stop doing that. That's at record 629. I did want to address the fact that plaintiff's cross motion below should not have been considered at all. First of all, the cross motion was not made on identical grounds as the motion that it was crossing against. The defendant third party plaintiff only moved against my client, the third party defendant. The defendant third party plaintiff did not move against plaintiff. However, the plaintiff's cross motion was made against defendant third party plaintiff's motion. Furthermore, the lower court's own part rules specifically stated that a cross motion would be considered made on the date it is made, and that its timeliness would not relate back to the main motion. Those
Just ask a question, was any of the appeal resolved, or a decision was made just to not argue some of the appeal?
So a decision was made to submit the portions of the arguments between my client and the third party.
Sure that it was just submitting, but you still want a decision on those issues. Okay.
Yes, Your Honor.
I would just like to say that what counsel said about the timeliness of the cross motion.
I'm sorry, you can't say anything at this point in time. Your ability to say something is ended, as is Mr. Curtis. So we're finished now. Thank you so much.
Thank you, Your Honor.
The argument is D'Artagnan versus Sprinkler.
Good afternoon, Your Honor. Stephen Dreyfus for D'Artagnan. May it please the court, this appeal presents what I hope for the sake of the court system is a very unusual question. Is it proper for a motion court to dismiss a well-pleaded 6-count complaint in an opinion that contains no legal analysis, does not cite a single case, doesn't say whether it's relying on 3211A1 or A7, doesn't state, discuss, or apply the requirements of either of those rules, and does not discuss or even mention the elements of any of the causes of action in the complaint, or even assert, much less demonstrate, that any of those causes of action are legally deficient. The motion court called D'Artagnan
Let me interrupt and ask a question. Regardless of what the decision below did or did not address, there are many well-established legal principles at play in this case. And my question for you is, we have before us an unambiguous contract as to what is or is not required. And if it was so important to your client to have the direct marketing capabilities that it wished to have to go forward, why didn't it explicitly put a provision in the contract itself, laying out at least to some degree what those requirements were, since obviously everything was heavily negotiated beforehand? And to the contrary, there's a provision in the agreement that says we're not relying on any representations outside the contract. That's my question.
Well, first of all, the contract was not heavily negotiated. The contract was a standard form agreement for an off-the-shelf product, contrary to the testimony that's provided in the defendant's brief, because I want to draw the court's attention, there are no affidavits and no testimony from anybody at Sprinkler, anybody who had any dealings with D'Artagnan whatsoever. The only affidavits in the case come from us.
Let me refine the question. If this result was so important to your client, why, and your client spent so much time talking about it beforehand, why didn't your client make sure that there was such a provision in the contract itself?
Well, I don't know the answer to that question. My belief is that Sprinkler was not willing to deviate from its standard form agreement because it is an agreement that's pre-printed. And
well, shouldn't that have raised a concern for your client? Then if your client had such a desire to have a certain type of agreement, this was so important to your client, why was your client then willing to sign an agreement which said absolutely nothing about these very specific expectations that your client had?
Well, because it was relying on what it had been told, and neither the merger clause of the agreement nor the no representation clause of the agreement applies under this circumstance.
But your client was represented by counsel. I mean, counsel negotiated the contract,
No, ma'am.
and the whole purpose. Your client did not have an attorney?
No, ma'am.
The whole purpose of the contract, the whole purpose of the relationship was because your client wanted the one-to-one the one-to-one targeting, specifically on Facebook and on Instagram, I believe.
That's right.
And so that was the whole purpose, because your client wanted to appeal to these additional customers. So again, I go back to Justice Kern's question, why not just make sure that it's included in the contract?
Well, the contract doesn't say anything about what the system can or can't do. It's not a contract just says, we are providing these services to you in connection with licensing this system. But there are multiple representations. The trial court just seized on one piece of the May 9th email.
Okay, so in that email, they come back to your client and they say, because of privacy considerations, we cannot advertise or whatever on Facebook and Instagram because of, I believe, because of their privacy considerations. But then your client can still enters into the contract, do they not?
And before they enter into the contract, first of all, to complete that, that's one piece of the May 9th email. It also says right after that, with that said, it's highly likely that the individual would receive the ads. And then in the very next paragraph of that same email, they say they're asked, can we serve ads in the case of Facebook to everyone who likes the company page? And Sprinkler answers unequivocally, yes. And then we have the affidavit of Wertheim and the affidavit of Kreitz-Moore that show that just as the trial court said they should have done, in view of these conflicting representations, they asked for clarification. They had subsequent meetings with Sprinkler before signing the agreement where Sprinkler confirms that, yes, you can direct target with Facebook and Instagram. Based on those representations, they were comforted and they signed the agreement. And
again, counsel, this is Judge Scarpula. Your client signs a document that says, I am not induced to enter into this contract, and I am not relying on any representation. I mean, straight up, that is not included in this agreement. And no, they are not all pre-printed forms. There are forms, there are appendices that are attached that are not pre-printed. So how can you come in after your client signs a document that says, I am not relying and I was not induced to enter into this agreement by anything outside what this contract says, and then say, but yeah, I was induced and I did rely on something outside the contract? How could someone protect themselves? Because frankly, all the emails you're sending back and forth show that this was a back and forth over a number of months, and many things were said, and there could be 100 disagreements.
But this
and
is
so how could a company protect itself from someone saying, yeah, I said I wasn't induced by any outside representations, and I said I didn't rely on any outside representations, but I really didn't mean that?
Well, Your Honor, the law is very clear.
I think the law is very clear. A specific disclaimer that says that I didn't rely on anything, not a general disclaimer, but here's my warranties and here's what I'm saying, and anything else is out is out.
But under Ladisinski and Hobart, the law is clear that this kind of a merger clause does not bar parole evidence of a fraudulent misrepresentation where the alleged misrepresentation is, quote, not specifically contradicted by any of the detailed representations or warranties contained in the agreement. And that's the case here.
So you're saying to me that unless, let me just ask, so your position is, unless that statement is, unless that I am not being induced by your statement that I could go directly to that, unless it's that specific,
No.
that means nothing?
No, Your Honor. What I'm saying is that if there had been somewhere in the agreement a provision that said that the software could or couldn't do targeting on Facebook or Instagram or a particular other platform, then the merger clause would say we can't disclaim that because it's there.
But how could someone know of the 10,000 emails back and forth and all the issues? This wasn't the only issue that you were raising. You raised a lot of issues in a number of emails. How could someone know that you were going to pick issue number 5 as the one that you are going to rely on, and that was the one that should be in the contract? That's my whole point.
Yes, but Your Honor just made the point a moment ago that they were going back and forth on this particular issue.
Not just this issue, lots of issues. I looked at, there were 5, 6, 8 questions. So you're saying that in the contract, the parties had to import all of those questions into the contract in order to make that I am not relying and I wasn't induced?
Well, your original question to me, Your Honor, was why didn't we do just that? You said, why didn't we put it into the agreement if it was so important to us?
I think that was Judge Kern, but I agree. Why didn't you?
But that was a question. I beg your pardon. But my point is that you can't simply say at the motion stage that this document, this fragment of an email is irrefutable, which was the basis of the court's opinion. Its merger clause discussion only, according to the court, related to 2 of the counts 2 and 4 of the complaint, not the rest. And the complaint was dismissed in full based on a merger clause argument that only applied in part. But be that as it may, I believe this is specifically the kind of general language rather than specific language that allows the gap in the agreement to be filled in by parole evidence, because the agreement doesn't say what it can do at all. It doesn't say anything about one-to-one targeting. It doesn't say anything about the limitation that Sprinkler wants to put on it, that it could only be done on something other than Facebook and Instagram. And when it's silent about it,
you have 2 minutes in rebuttal. Yes, respondent.
Yes, may it please the court. This is Gavin Murdy on behalf of the respondent in the matter. I will keep my remarks very brief. I think your honors from your questions fully understand our position. Briefly said is that this pertains to a supposed performance warranty about the product. That performance warranty is not included in the contract. The statement of work which accompanied the master services agreement was specifically negotiated for this particular deal. Your honors were right about that. This is not simply a form contract. It was negotiated in terms of what the software would be. That provision is nowhere in the statement of work or the master services agreement. So,
Counselor, is there anything which would allow us to go outside of the agreement to even consider any type of parole evidence?
No. There's an entire agreement integration merger clause in 10.1 of the master services agreement, and most particularly a no inducement, no reliance clause in section 10.8 of the master services agreement. And that makes clear, as Justice Carpula read earlier, that the contracting party here, the plaintiff, expressly disclaimed reliance upon any representations or warranties outside of those expressly set forth in the agreement. And that the reason that language is there is exactly the argument we're having today, so that the parties have certainty as to what their obligations are or are not, and that defeats the claims for breach of contract, the fraud-based claims that are pled in the complaint, as well as unjust enrichment and declaratory judgment. Thank you, Your Honors.
Any questions?
Excuse me.
Thank you, Counselor. Yes, Mr. Dreyfus, you have 2 minutes of rebuttal.
I want to make clear to the court that there is no evidence of negotiation of the contract. There is evidence of discussions, asking questions. What can it do? What can it do? That's not negotiating the contract. It was after the representations were made about what it could and couldn't do that the contract was signed. That's not a negotiation. Secondly, the merger clause, the no representation disclaimer in section 10.8 was not relied upon by the motion court at all. And that fails because the disclaimer, once again, does not identify specific representations that are expressly disclaimed. And the capabilities of the Sprinkler software in this case were uniquely within the knowledge of Sprinkler. And as this court held in Basis Yield Alpha Fund, you cannot preclude a claim of justified reliance by using a disclaimer unless it's made specific and the alleged misrepresentations or admissions did not concern facts that were peculiarly within the seller's knowledge. The key point here is the point that the Court of Appeals has made, which is that you cannot have a situation where a sophisticated seller can make all sorts of representations and then stick in the agreement a generalized merger clause and then all bets are off. If the agreement is supposed to contain all of the conditions of the agreement and the deal between the parties, fine, then the merger clause can apply. But in this case, the agreement did not contain anything about what the software could or couldn't do. And in the absence of anything about what the software could or couldn't do, or whether it could work on Facebook and Instagram or not, the merger clause cannot bar parole evidence, which is admissible to fill in the gaps where the contract is not specific. And that's the purpose of our argument. That's our position. And these were lay people. They were dealing in an area that they knew nothing about. They know about foie gras, but they don't know about software.
Well,
And
counsel, let me just interrupt you. Counsel, wasn't the social media manager dealing with this issue? It wasn't the chef. There was someone called the social media manager, and the contract requires you to have somebody who understands this kind of issue, right?
Well, her title was social media manager.
Well, you're not called social media manager because you don't know anything about social media, right? This is not like a case where.
But the point is that the issue here about direct targeting on Facebook and Instagram was not something that she knew anything about. And in fact, she was relying on Sprinkler coming and saying, yes, we know all about this. We're specialists in it. We're going to show you how to do it. So her title is not the issue.
Thank you very much. We have your briefs. Thank you so much. Next matter is Solomon versus U.S. Tennis Association.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. With your permission, we have a couple of, I think, procedural issues that I need to deal with before we get to the substantive, because obviously if you resolve the procedural issues against me, you don't actually need to deal with the substantive. As I read the defendant's briefs, there are two essential arguments they're making. Argument one, an appeal from an order granting additional discovery in the form of an additional examination before trial is not appealable as of right. You need leave. They cite the case of Scalone against Phelps Memorial Hospital Center, which says exactly that. But it also adds that the court can treat the notice of appeal as one seeking application for leave and grant leave, which it did in that case. And the second issue is we did the deposition. Since we did the deposition, the issue is now moot. I think they're right on the first point. I think once you do the deposition, you can't argue that you don't have the deposition. But on the second point, I believe that they're incorrect. And I uploaded a case to the court yesterday called Matter of New York City Asbestos Litigation.
Before you go on, if they're right on the first issue, then isn't this appeal moot?
It is not, because the basis of the motions below, as articulated by the defendant, was related to privilege. Plaintiff's position was she did not put her condition in issue with respect to any brain scan because she had a.
But counsel, the decision that's on appeal is a decision to allow a deposition and to allow authorizations. That's a decision on appeal. The deposition has taken place. The authorizations have been provided. So I am mystified why this appeal is not moot on that basis. We're not deciding an issue of privilege. We're deciding whether the court properly did or did not allow those things to occur, and they've already occurred. So it would be an advisory opinion.
Judge, if that's the, remember, there was also a general or purpose clause, and if that is in fact the court's ruling, I don't have any disagreement with it. But I don't want this to come back if we go to the trial court and they say, no, the appellate division affirmed this is material that's relevant and you did waive the privilege, because the basis
So Mr. Isaac, why would you think that it would be anything other than what Justice Kern just stated? What would lead you to believe that? Because I agree, in the lower courts, in the motion court's decision, I don't see anything that would talk about privilege or admissibility of the deposition testimony.
Yeah, Judge Weber, my concern on that is this. You know from reading the record, this judge has detailed discussions on the record. I think it was 97 pages or so, which got incorporated into the fact sheet. The basis of the motions all related to privilege. So my view of the judge's decision was that it was a privilege-based decision, even though it could certainly be read as being a procedural-based opinion. That's my only concern. It wasn't like the judge wrote a detailed opinion. He did a terrific job with respect to the argument. And if this court, in fact, is of the opinion that this was simply a procedural issue, I don't have any problem with that at all. My problem is I think that under the Brito against Gomez decision, which of course went up to the Court of Appeals, got reversed not on a substantive ground, but a factual ground, we don't put the plaintiff's medical condition in issue, except if there's a specific waiver. And I'm citing to what you said in Brito against Gomez, it's 186 AD3D at 1, page 7. Plaintiff's waiver of his physician-patient privilege is limited to those conditions that he affirmatively placed in controversy. Our position, look, I think as a plaintiff's lawyer, I'd love to have a brain damage claim on top of a complex regional syndrome pain situation and a torn hamstring. I don't have it. So the problem for the plaintiff is if that comes into evidence, it could hurt him at the trial, given the fact that he's not making that claim and this is an unrelated condition.
So this is Judge Kern, isn't the trial judge going to ultimately have to make that determination as to what evidence will or will not be allowed at the trial of the action, and whatever did get found out during this deposition and the authorizations, won't it ultimately be the trial judge who decides whether or not anything that was obtained from this discovery will or will not be admissible at the trial? Or an eliminate motion?
Yes, Justice Kern, that is going to depend in large measure on how any trial judge would view the trial court's original decision and how they would review this court's decision. As you know, this court's decision is binding on all lower court judges in the appellate in the first department, and it's also binding on all lower court judges everywhere in the state if there's no contrary opinion. So again, I don't want to belabor a point. I know it's late. I try not to go over my time. If your opinion is that the only issue that is currently before this court is whether the deposition should have been held and whether the material should have gone in, then I don't disagree with you.
Okay, so let's hear from U.S. Tennis Association. Do you believe that the issue is anything other than what we have been discussing?
Good afternoon, Your Honor. Thank you. Megan Brown for the U.S. Tennis Association. No, the court has hit the nail on the head here. This was a discoverability issue, evaluated to be evaluated by this court on an abuse of discretion standard. No abuse of discretion here with ordering the further deposition based on the injuries that the plaintiff herself put in controversy. Was this brain scan? Were these additional records discoverable to find out if they would be related to the injuries she's claiming? She's claiming a loss of ability to work in the future and extensive medical expenses. And as you've already pointed out, a couple of judges have already pointed out this afternoon, admissibility hasn't been decided. This is just discoverability. The order was properly made. The discoveries happened. I think there's a mootness argument here I'll defer to my colleague on. But, as far as an abuse of discretion, it just didn't happen here. The relevancy was apparent, and you've already hit the nail on the head. So with that, I'll rest on my brief.
Thank you. So who's this? Next is Levy? Is that who we have?
Yes, Your Honor.
Yes.
Yes.
So same question to you. Do you believe that it's anything other than what we have been discussing?
No, this is strictly the review of a discovery ruling to be made on a case-by-case basis, depending on the facts in this case. The trial court judge in this case certainly took his time to make sure he understood the facts pertaining to this particular ruling and made a limited ruling to allow this discovery. I believe any decision as to admissibility is yet to be made, depending on what's in the records and what gets presented to the court later.
Thank you. Is anyone else on this one? No, right?
Yes, Your Honor.
Oh, Ms. Ivy, sorry.
Yes, no problem. I just want to mention, I agree with everyone. I just want to mention that on page 15 of the reply brief is the first time that plaintiff's counsel requested that this court actually preclude use of the evidence. And obviously we have a problem with that request. We think that's a motion in limine that if they have grounds to make, they can make. But I think the relevance of the information is apparent on the record.
Thank you. Anything further, Mr. Isaac?
No, Your Honor, given the tenor of what's been said, I will waive my rebuttal. Thank you so much.
Thank you all very much. Have a good day. The next matter up is Houston Casualty or Houston Casualty versus Cavan.
I'm going to go with Houston, Your Honor.
I'm a New Yorker. It's Houston Street. Sorry.
Glenn Kaminsky with the firm Omni Demers McManus, counsel for the defendant appellants. We respectfully ask this court to reverse the decision of the Supreme Court and grant the defendant's motion, which was for summary judgment. I'll try not to belabor this case very much. Despite the long history of this case, the issue here is fairly straightforward. Houston failed to issue a timely and proper disclaimer in accordance to the Puck defendants in accordance with Insurance Law 3420. Notice was made by the Puck entities by way of the order to show cause in June of 2015, specifically in the answer 162 of the record. To the extent that Houston issued a disclaimer, it would have been in their answer, in their complaint in February of 2016, some 8 months later.
Concede in your own complaint, though, when you moved to intervene, that all of this had already taken place, and that would totally undercut the argument you're making now?
Respectfully, no, because what was alleged, and of course it is alleged upon information and belief, and you can argue things in the alternative regardless, but they weren't admissions, they were statements which may or may not have been true. They were allegations being made. But what we found from the actual facts, and this is raised very easily in our reply brief, that the only tender was made by York on behalf of Kushner. The only response was by Houston Casualty to Kushner.
Well,
that letter never went to the Puck entities.
Counsel, this is Judge Kern. Let's discuss that also, completely separate from your concession, your own complaint. When Houston or Houston denied coverage, didn't it deny coverage to Kushner companies and their affiliates? Why wouldn't Puck be an affiliate in this circumstance of the Kushner companies?
I don't know that they're an affiliate of the Kushner companies. Is there any evidence in the record to show that they're? You got to remember, the court searched the record and granted Houston summary judgment. Houston never put forth any evidence that could possibly applied.
What is the relationship? What is the relationship between the Kushner companies and the Puck defendants?
I believe the Kushner company at some point in time, and not at the time when the construction management agreement was signed, but at some point in time was acting as an agent of the Puck entities. But again, this is not something that's fully developed. But what we do know is the Puck entities entered into a construction management agreement with Houston's insured Cavan that required that the Puck entities be named as an additional insured. And there came a point in time the Puck entities tendered that defense to Houston, and then it was 8 months later before there was ever a disclaimer. And so what we get in response for Houston is Houston says, well, Insurance Law 3420 doesn't apply. Well, that's not what this court said in JT Magnin which is cited in page 4 of our reply brief, but also what this court said just over a month ago in the Vesta Engineering versus Everest case of January 12, 2021. Justice Weber and Justice Scarpola were both on that case that indicate that Insurance Law 3420 would apply and that a timely disclaimer is in fact required. So I think that's really the issue. Now, Houston puts a lot of emphasis on this court's prior court decision in February of 2018, but that order addressed Cavin's ability to get coverage under the Houston policy, not PUC entities, not anyone else. And the court below actually made note of that fact, that the decision rendered was only as to the exclusion applicable to Cavin and not whether PUC was entitled to coverage. Houston also goes on to claim that somehow the PUC entities cannot assert a 3420 claim at this juncture. I would say to this court that PUC entities certainly have asserted affirmative defenses regarding the untimely and defective disclaimer. It set forth a full counterclaim, notice pleadings in the great state of New York. Clearly, there was no waiver by the PUC entities. So what really happened here is, as opposed to a waiver by the PUC entities, what we have is a statutory preclusion by Houston in failing to issue that timely and proper disclaimer. And unless this court really has any questions for me, I'll rest on my brief.
Any additional questions? No? Yeah, Mr. McCormick?
Thank you, Your Honor. May it please the court, Aidan Middlemas McCormick, counsel for plaintiff respondent, Houston Casualty Company in this matter. Just for housekeeping, as the court may be aware already, there's another related appeal that will not be heard today. All other issues in this case have been settled. This is the remaining issue. And so no decision is needed on that related appeal. This is also the third time that I'm sorry.
I just have a question. What is the relationship between PUC and Kushner?
They are all affiliated companies. They are the owners and managers of the property in question. They are all insured by Federal Insurance Company, their insurance company, and that Federal Insurance Company, using its claim service, York Claim Services, submitted the claim to Cavin. And of course, Federal Insurance Company hired a well-respected insurance defense firm to seek recovery of the settlement and payment from Houston Casualty. So it is what you would think it is. It's the real party at interests are all insurance companies, for better and for worse. This is, as I was saying, the third time we've been before this honorable court on this case, and hopefully the last. We have two prior decisions from this court saying that the construction management for a fee exclusion bars coverage. The lower court, for its work, has 6 decisions to the same effect. This time, the appeal is focused on the PUC's argument that Houston Casualty waived its rights, but I would respectfully suggest that Justice Kennedy got it dead right. She recognized, and it's really well detailed in her decision in the record on page 14, that the tender was made on April 8, 2014, and that within 30 days, Houston Casualty issued a detailed denial letter, which specifically had cited the construction management for a fee exclusion. That should really end the matter, but as the court has already pointed out, it really doesn't end there. There's much more. Ultimately, the PUC defendants, all of them moved to intervene in the case. They moved to intervene in the case because they had been denied coverage and felt that their rights were in jeopardy and that they needed to assert their rights. And the lower court granted that motion. In so doing, the court relied upon the representations of the PUC defendants, and quite candidly, so did my client, to the court and to everyone, that they had their coverage denied on May 8, 2014. So you can imagine the surprise we learned later that they feel that we never denied coverage and that somehow owed them another denial later in time. It's very clear, particularly in paragraph 46 of their papers, that's page 173 of the record, where they specifically say that they being the PUC defendants, were rejected coverage on or about May 8, 2014 by a representative of Houston Casualty Company. It's also in their briefs as well. They argued, and there's nothing wrong with these submissions. They're all perfectly accurate. It's just the later about face that we're concerned about. On October 20, 2015, page 300 of the record, they pointed out that the very complaint that they were intervening in sought to deprive them of coverage because it denied coverage for Cavan and anyone. It's also on page 309 of their papers, where they specifically said to the lower court that Houston Casualty's purpose was to extinguish their rights, and that was the basis under which the trial court let them into the case. So contrary to their arguments now, if I may, the record is unmistakably clear, as Justice Kennedy so recognized.
But I thought that they were now arguing that these were mere allegations and there is no real proof in the record.
So I just did hear that argument now, Your Honor, that these are mere allegations, but they're not the unspecified vague allegations one might see. It's very specific. For example, paragraph 46. A tender was made on about April 9, 2014 on behalf of the defendants. And then they list each one, the Puck defendants, the Puck residential, and the Kushner companies. And then the next paragraph, again, very specific. On May 8, 2014, coverage was rejected, that's quotes, by a representative of Houston Casualty Company. They can be referring to one thing and one thing only, the documents that they submitted, which are the tender that was made by Federal Insurance Company's claim service and the rejection of that tender by Houston Casualty. And I think, if I may, Your Honor, more fundamentally, what is an insurance company, or frankly any company, supposed to do to protect itself? When they intervened, the trial court understood, as did we did, Justice Wooten, that they had told everyone that they had coverage denied. That's why they were let into the case. Much later, after submitting briefs to the trial court, after coming before this court, literally, not just virtually, to argue an appeal, after moving to re-argue that appeal, after all that happened, after two decisions by this court, ultimately, then all of a sudden, haha, I got you, I've got a brand new argument, an argument that was never pled, that when they stood before you in this courtroom back 2 years ago, they never raised once, that they never raised to the trial court judge. It seems to me that at best waiver is waived. Also, as you know from my papers, and I realize my time is running out, this is ultimately just an insurer versus insurer dispute. 3420D has no place in this case, but even if it did, the May 8, 2014 denial was timely and effective. If there are any questions, I'll rest on my briefs.
Any questions? Thank you. Mr. Kaminsky?
Yeah. Page 272 of the record is the tender on behalf of York, by York on behalf of Kushner, which only names Kushner and names no other entity at all, and to which that is the document the May 2014 disclaimer is issued to, and that disclaimer does not go to the Puck entities at all. So what Houston's trying to do is say, oh, you made this allegation based upon your mistaken understanding of what happened, and we're going to say, well, the allegation is the facts instead of the facts being the facts.
Well, what they're saying is that you took a posture before, and now you're changing that posture because now it's convenient for you to change the posture. Right?
No.
You intervened before, and you allege one thing, and since you lost that argument, now you're coming up with a new argument. That's what they're saying.
Well, and they're incorrect, because when we intervened, there was a motion pending, Houston versus Cavan. And so the issue at the time, and what was decided by this court previously, was whether or not Cavan was entitled to coverage. And certainly that's an important issue to the Puck entities who would potentially have claims against Cavan. We are, after all, a potential claimant against them. And under the J.J. Wicks Hartford decision, we should have received a copy of that disclaimer to Cavan anyway. But that's not the issue here now. That was the issue there. Rather, Cavan was entitled to coverage, and we wanted them to be entitled to coverage, and we wouldn't be here now because we'd just pass it through as a matter of indemnity.
How are the dates different when you're talking about Cavan as opposed to when you're talking about this action? I mean, would not the dates be the same? It's either one set of dates, or it's not that set of dates. I'm not really understanding why it would be any different.
Well, it's different because you have an obligation. The carrier has an obligation to treat each insured as its only insured, and as a separate insured. And so when Kushner gives notice in April of 2014, and a disclaimer is issued in May of 2014, and it doesn't go to us, how are we getting our benefit of what being treated as an insured?
How is it different? You're stating that it was first tendered on June 15, 2015. That's what you stated when you
That's correct.
Intervened, right? And that on February 4, 2016, and you denied coverage, and then Houston denied coverage on February 4, 2016. So my question is, why would it be different in terms of the assertions you made in your motion to intervene as opposed to with the case with Cavan?
Sure, because what we're at the time we're concerned about whether or not I guess where maybe I'm getting lost with you is I'm thinking when we intervene, there's a motion pending Houston versus Cavan, and it all pertains to Cavan's coverage. Okay, we're not at that point in time even addressing the coverage issues that are involving us. Okay, so we do when we intervene, that is their notice that we want to be in this case because we want to be heard with regard to coverage for Cavan. But at the same time, when we intervene, we're asserting that we're entitled to independent coverage ourselves. Now, it wasn't subject to the motions in 2018, but it was subject to what we put in our answer and what we put in our counterclaims. So that's just come to fruition now. So I think that it addresses your issue. Is that
no.
There's different coverage.
No, it doesn't. Because I still don't understand. Either they tendered on April 9, 2014, or they didn't tender on April 9, 2014.
It's a fact.
I mean, either they did or they didn't, regardless of whether we're talking about Cavan or we're talking about Houston. I don't understand. But
okay,
anyhow, thank you so much.
Let me try again.
We have the briefs. We'll take a look at it and all allegations. Thank you.
Thank you.
Last case for argument is People v. Tyrell Williams. I am recused, and Justice Singh is sitting.
I'm here.
Thank you.
Okay, counsel for defense.
Good afternoon, Your Honors. Jan Hoth for Appellant Tyrell Williams. Defense counsel's acquiescence to the admission into evidence of an unauthenticated video is indefensible. The evidence against appellant in this case centered largely on the testimony of Mercedes Glover and to a lesser extent on Christina McFarland. Mercedes Glover, of course, is the spurned sexual companion of my client's brother. And Christina McFarland is a woman who was married to one of the victims, but never spoke to the police at the scene, never spoke to the DA when everyone else was, and just suddenly popped up prior to trial. These were all issues of credibility that defense counsel should have been exploring, and he did to some extent. But allowing the prosecutor to, not just allowing the prosecutor, but agreeing that this video was admissible, gave the prosecutor a third witness. And that third
defense counsel used the video also to assist defense counsel in the defense of this case by arguing that the video would not establish that defendant was a shooter. And wouldn't that be a basis for why defense counsel would decide not to object to the video?
Your Honor, we can always find some basis for why someone might do something, but obviously once the video is in, then defense counsel has to use it. But if it's not in, we have two women who are not totally credible, not the most credible witnesses. But now we have a third witness, a video.
And so this is Judge Scarpula. Isn't that video like grainy and it's difficult to tell who's whom? So couldn't there be a strategic decision to let it in to say for cross-examination purposes, precisely for that reason, to say, You can't tell from this video who it is. And if the plaintiffs, the people's witnesses testify to that, then they're mistaken, right? Doesn't that, I mean, that seems as good a decision as any other decision.
Well, Your Honor, we have two women testifying to their purported version of events. And then we have them testifying that, look, you can see exactly what I said happening on the video. And the video is grainy.
Video where you can't tell anybody there. And that was cross-examination fodder, right?
But the point is, the jury now hears them saying, yes, see, that's exactly what I said happened. Why should the jury ever be hearing that in the first place?
Counsel, could that video have been admitted even over defense counsel's objection? I mean, it was authenticated to date, time, and place, correct?
No, it was not authenticated in any way whatsoever. You cannot ask, they didn't even ask the witnesses who were narrating this video the simple question, is this an accurate depiction? They couldn't ask it because the video was too grainy. So they didn't want, how could the witness say, yes, that's an accurate depiction? Instead, they relied on her saying, this is what I see happening. This is who I see doing it. And guess what? I already testified that that's what happened. So this video corroborates my testimony. That was the DA's argument in summation. If the video corroborated Glover and McFarland's testimony, the jury had to convict. If it did not, the jury had to acquit. Right there.
Assuming you're correct about all these things, which I'm not saying you are, but assuming you are, I don't understand why. Two questions. First, why any error is not harmless, since there were two eyewitnesses who gave very detailed testimony, and also with respect to ineffective assistance of counsel, we've already identified two reasons why counsel may not have objected. So why don't you have to make a full 40-10 motion? So those are two questions.
Well, I heard the question that Your Honor believes this would probably be better brought by a 440 motion in order to explore defense counsel's reasons for not simply allowing, but agreeing to have this.
Because we've already articulated for you two reasons why defense counsel may have decided not to object to the video. And so there's two clear reasons that clearly would seem to indicate a full 40-10. So then my other question for you then is also about the harmless error, because your argument was not properly authenticated. So even if you could win on that argument that it wasn't authenticated, why wouldn't any error in this case clearly be harmless?
Well, I think that I've already touched on it a little bit. The purpose of that video, what that video did, was corroborate two witnesses whom counsel needed to show were not credible. But they had a video and the witnesses are testifying. That's what the DA said in summation. If you find this video corroborates their testimony, you must convict. But the only evidence of what was on the video was coming from the same witness who's now saying, well, see, it corroborates what I said. We had no independent corroboration that that video was an accurate depiction of the events that happened that day. We had self-authentication by the witness herself. I would really like to take a few minutes to go to sentencing if there are no other questions.
Go ahead.
I don't want to run out of time. Sorry, Your Honor, because I do want to address sentencing. I want to say that, yes, indeed, as my adversary points out, a main goal of sentencing is punishment. As a civilized society, we do need to punish people for their unlawful behavior, but punishment must be tempered by rehabilitation. That is, will the defendant be able to re-enter society as a productive member?
Counselor, this is Judge Singh. Did your client ever express remorse for the events that occurred here?
Your Honor, I would like to say that my client apologized twice, but I think going beyond that, the bigger picture here is my client chose to put the people to the burden of proving his guilt beyond a reasonable doubt. Any attorney representing him is not going to allow him to accept responsibility, to express remorse. If we adopt that argument, then basically what we're saying is only those who plead guilty are deserving of leniency. But people who plead guilty don't get a lighter sentence because they're accepting responsibility or expressing remorse. Many of them don't.
But isn't that a fair criteria for a court to consider in terms of how, whether or not the client accepts or the defendant accepts responsibility for his or her actions?
Well, Your Honor, how is a client who's represented by an attorney and his trial attorney told the sentencing judge that he had been told not to speak? How is a client who is putting the people to their burden of proving him guilty beyond a reasonable doubt supposed to be expressing remorse more than what Mr. Williams did? He apologized.
I have 2 minutes of rebuttal time.
Thank you.
People?
May it please the court, Cynthia Carlson for respondent. The defendant's conviction for the triple shooting on a public street in the Bronx, injuring 3 people, nearly killing 2 of them, should be affirmed. Although counsel complains that defendant had ineffective assistance of counsel at trial, as this court has noted, the record makes clear that there was a strategy by defense counsel. The Court of Appeals in Evans even noted that if ineffective assistance of counsel claims the court noted that if the record reveals a trial strategy that may well have been pursued by a reasonable attorney, then it's not ineffective assistance of counsel. So there's no need to even have a 440 now, because the record here indicates that the able attorney, Murray Richmond, had every reason to not bring the jury's attention to a piece of evidence that he was trying to downplay. As far as the sentencing of the defendant, the people...
You don't want an advisory opinion from us, though, on that, I assume.
No, I think, it's pretty clear that counsel gave effective assistance, and that the admission of the videotape, even if we're assuming that Mr. Richmond should have not consented to the videotape, the testimony that came out with all of the witnesses, including the third witness who didn't actually narrate the videotape but said that he saw it and it contained the entire incident, all go to the authentication of the video. So there would be harmless error if it was a single error by defense counsel. And as far as the excessive sentence claimed by defendant, Your Honors, I would just note the facts of this case are particularly egregious, that the defendant followed people into the street, chased them, and shot at them as they were fleeing away, nearly killing 2 of them. While Judge Singh did note or did ask if the defendant ever apologized or accepted responsibility, he did not. In fact, at his second sentencing, the resentencing, the only thing he said was, quote, "I am sorry that this incident ever occurred." That's not an acceptance of responsibility. That's not an apology. That's a distancing himself from his actions.
And counsel, let me just, his sentence was reduced, correct?
Correct. It was reduced by nearly
substantially.
Yes, correct. So I see that I believe everything is covered in our brief, so I will concede my time and request the court affirm the conviction.
Your Honors, yes, Mr. Williams' sentence has been reduced, but let's be honest, 30 years was even more than the DA was originally asking for. So it's unfair to Mr. Williams.
So Counselor, I'm sorry to interrupt, but the question is 3 people were shot in this case. So why, under circumstances, is that not a fair sentence, given the gravity of the harm?
Well, let us remember that 2 of the people who were shot did not testify at trial.
Oh, but they were still shot.
And one of them appeared at sentencing on behalf of himself and his brother and asked the court to show mercy to my client. Their mother appeared in court at sentencing and asked the court to show mercy to my client. So the people specifically...
So maybe, Counselor, that would have been a good time for the client or the defendant to to accept responsibility when others are advocating for mercy on his behalf,
But
no?
as his attorney pointed out to the judge, he had been told by his attorney not to speak. That's something that we attorneys routinely do. We tell our clients not to speak. He told the court, I'm telling him not to speak because this case will be going up on appeal. So you can't then turn around and say, well, he's supposed to ignore his attorney's advice and ignore the fact that he has a right to appeal this conviction and accept responsibility and simply throw himself on the mercy of the court. No, he has a right to put the people to their burden of proof. And he has the right to say that 16 years when the people who were harmed were asking for mercy, when he has done everything and more to show that he is not the 17-year-old kid who committed this crime. And
Thank you very much, counsel.
Thank you.
This is the end of our session for today. I hope everyone enjoys the rest of their evening.